May it please, your Lord. Motion item number 33, my Lord. I am supposed to file an affidavit, my Lord, that will be filed today, my Lord. So let the matter be fixed next week.
Next week.
I have taken the consent of the other side.
On the prayer of Mr.
Ardi.
Are they learn counsel for the petitioner? You want to file reply?
Yes, my Lord.
List this matter after 2 weeks. So as to enable him to file affidavit in reply.
May it please your lordship?
Yes,
Lordship, I beg to mention item number 20 of the daily list.
20,
20, lordship.
20.
Yes, lordship.
Yes,
Lordship, my senior has some personal difficulty today. Lordship may kindly fix this matter on some other date.
on the prayer of MS so-and-so, learned counsel.
Please on behalf of Mr. H.
Please,
Das.
on behalf of Mr. SK Das, learned counsel for the list this matter after 4 weeks.
I beg to mention item number
Yes.
35 to 38, and affidavit has been filed in this
35
matter.
and 36.
35 to 38,
Yes.
an affidavit has been filed in this matter. I want to file a reply. Lordship may give 1 week time.
List this matter, no, on the prayer of Mr. BP Bora, learned counsel for the petitioners. List this matter after 3 weeks,
Oh, 2 weeks, Lordship.
2 weeks, so as to enable him to file affidavit in reply. Yes, deeply.
Concerning the address, I'd like to mention item 66, your lordship.
Ah,
Lordship, in this matter, we will be filing a reply, your lordship.
60?
2 weeks time, 66, your lordship.
Yes. On the prayer of so-and-so.
EK Bora on behalf of P. Borga,
Hmm.
counsel for ONGC.
Lordship, there is interim order.
Learned counsel for the petition. Appearing on behalf of Mr. P. Bora, learned counsel for respondents. Huh? List this matter after 3 weeks. 2 weeks. Or so as to enable him to file affidavit in opposition. MS so-and-so is present for the petitioner. Interim order passed earlier shall continue. Yes.
May it please your lordship. My lord, I beg to mention item number 34, lordship. Comment has
34.
filed, Lordship, they are affidavit, lordship. I want to submit my reply. I need some time, lordship.
Same order on the prayer of so-and-so. Majumdar.
Lordship.
K. Majumdar, learned counsel for the petition. List this matter after 2 weeks. So as to enable him to file affidavit in reply.
Much obliged, lordship.
Item number 10, I have
Yes.
instruction to withdraw the matter, my lord, liberty to approach, my lord, if occasion arises.
Approach?
My lord, it's liberty to approach if occasion arises in future, my lord. My lord, in this case, media fellowship was withdrawn from the online reporters. That was under challenge. Government has given an instruction that last 5 years, there is no media fellowship. So time being, my lord, there is no necessity of
The
that.
government policy, is it an statutory right?
A discrimination was made, but I want to withdraw, but with liberty.
Withdraw, better withdraw, otherwise it will be dismissed.
No, my lord,
Anyway,
but liberty
Mr.
may be there, my lord.
Mr. B. Chakraborty, learned counsel for the petition, submits that he has an instruction to withdraw this writ petition. Prayer for withdrawal is accepted. Accordingly, writ petition stands
Liberty may be there.
closed on withdrawal.
Liberty may be there, my lord. Occasion arises, we can still assail, my lord.
Then with the liberty, so and so. On withdrawal and with the liberty as prayed for. Otherwise, yes.
May it please, my lord. My lord, daily list item number 7, 8, and 9, my lord. I'm appearing for the petitioner. My lord, consent has been taken from the other side. Discussions are going on between the parties, my lord, for settlement. So, my lord, may kindly adjourn the matter for 4 weeks, my lord.
It's 2019 matter, still you are on for
Understood, my lord. My lord, but
Okay,
that's
you're
I'm
you're-
Enu Upadhyay, my lord.
for petitioners.
Petitioner. 7, 8, and 9.
Same petitioners, right?
Yes,
Petitioner. MS N Upadhyay, learned counsel for the petitioner, 7, 8, and 9, submits that efforts are being made to settle the matter outside the courts, therefore fresh for listing of the matter after 4 weeks. Whereas allowed list after 4 weeks.
grateful, man. Grateful.
Lordship, item number 39 may kindly be taken up in the next week, my lord, on Tuesday, my lord. I'm for the BTC, my lord, for responding in this matter.
And taken consent. Not next week, after 2 weeks. On the prayer of MS B. Bora. Learned
Sure,
counsel, learned assistant counsel BTC.
She had talked to the counsel for the petitioner. He has got pressure from his client.
Ah.
So he has got urgency. Lordship on
So we'll take it
Tuesday.
up today. There is urgency.
Maybe tomorrow or on Tuesday, your lordship.
Tomorrow it is not
On
possible.
Tuesday kindly
Yeah,
be.
let
Otherwise
this
he'll
letter be listed after a week. After a week.
be given them. Otherwise the
Private-
council will be offended, Mr. K. Sharma.
Tell him that, tell him that court is not inclined, 2025 matter.
After
Otherwise,
a
we
week,
we could have taken it up today, if there is a urgency. So, next week, after a week,
May I please, your lordship?
yes,
With the consent of other side, I beg to mention item number 14, lordship.
yes.
The affidavit could not be filed, lordship. I pray for some time, lordship.
On the prayer, Mr. SS to learned State Council. Further 2 weeks' time is granted to file affidavit in reply. Yes, list after 2 weeks.
Date may be fixed, lordship,
Eh,
because
give that a
2 weeks. Oblige, your lordship.
May it please your lordship. Lordship, this is with regard to item number 3 on today's list.
item number
3.
3, yes.
I'm appearing on behalf of Mr. DK Das. He has underwent an eye surgery. So we have informed the other
It's a
side.
part matter,
Yes, your lordship, but because of this situation only we are.
so we'll release from the part heart.
Lordship.
Release from the part heart.
Has held it substantially, lordship.
That's the whole problem. So we give preference to the part heart matters.
Lordship, only because.
We also, I mean, work hard in the night.
I do understand, lordship. But,
We go from here at 7:30 to 8 o'clock. And after 10 minutes again, we in the chamber.
Lordship, he has undergone some surgery, so he needs to recover from only.
Should not say whether it takes a toll to us. But then can't help it, would accept the job. So part heart matters, it's very difficult. We come prepared. Or else you could have given a, I mean, adjournment slip. 3 days. You said 29 and 30 yesterday. Anyway,
speak also, lordship.
adjournment slip has been circulated yesterday. Okay, then that was my I mean, mistake. I thought 29 and 30. For adjournment, huh? List of, although this matter, this matter is a part of matter, comma, considering that Mr. DK Das, learned counsel for the petitioner, is indisposed, comma, on the prayer of made on on the prayer made on his behalf. Let this matter be listed after
2 weeks, 2 weeks, your lordship. 2
Hmm?
weeks, your, 2 weeks, your
2
lordship.
weeks.
Speak of,
2 weeks, Mr. RKD Chaudhary, learned DSJ is present for the list of, list on, give a fixed date.
that's fine, lordship.
May I please? I beg
Yes.
to mention item number 17, my lord, with the consent of other side, my lord, kindly adjourn for the day, my lord. 17, my lord.
On the prayer, Mr.
K. Uddin, my lord, respondent on 9A, my lord.
You didn't take it, have you
Yes,
taken-
yes, my lord, I have
On
taken.
the consent of learned counsel for the petitioner, praise for listing of the matter after 2 weeks. Prayer list after 2 weeks, yes.
There is interim order, my lord. that-
Interim order passed, the letter shall continue.
Please.
May it please your lordship. Lordship, may I mention item 29 and 30?
Hmm.
We've circulated letter. I
Yeah.
appear for petitioners in item 29 and respondent number 7 in item 30. I'm
Seven.
praying for
Okay.
time to file reply.
On the
affidavit.
prayer of MSG Goswami, learned counsel for the petitioner in WPC 337/2025, and consent being given by the learned counsel to the respondent, let these matter be listed after
Lordship, after 2 weeks, on the 6th,
2
it may
weeks.
be listed, Lordship.
2 weeks.
6th, Lordship. I am for the petitioner in 30, Lordship.
Yes, urgency is there.
Agency is there.
council is not.
I am appearing for the Mahakam Autonomous Council. Lordship, we have to file one affidavit, so may I?
So we'll do it, fix after 3 weeks. We'll give the date, after 3 weeks. 9th of,
9th of February. 9th.
is it 3 weeks? No. Will it be possible?
Yeah. It's nearly 3 weeks, 18 days.
18th of February.
18th of February.
May I please, your lordship? With due consent from the other side, lordship, I beg to mention item number 42.
42.
42, it may come after 3 weeks, lordship.
42.
42.
Yes, on the prayer, Mr.
Interim is there, lordship. Yes, Sharma.
A. Sharma, Learned Council for list this matter after
3 weeks.
3 weeks. Interim order passed earlier shall continue.
My lord, in item number 65, my lord,
Hmm.
there was IA for impleading has been filed pursuant to the order in the writ petition, my lord. So that is not tagged with the record. I may be allowed to tag the same, my lord, to the record, my lord.
You'll take it or the registry will take it?
My lord.
You call for it.
Yes, sir.
Call for it.
Yes, ma'am. Yes, ma'am. Oblige, ma'am.
May it please your lordship.
Hmm.
When I pray for an adjournment of item numbers 48 and 49,
Yes. Yes.
I pray for an adjournment, my lord.
Okay. On the prayer, Mr. S. Banik, Learned Council for the petitioners, these matters after 3 weeks.
Oblige, lordship.
Please, your lordship. I beg to mention item number 61
Yes.
on the first lead.
Hmm.
Lordship, we'll file an affidavit today at the end of the day. So matter may be kindly adjourned and fixed on for.
On the prayer of Mr. NJ Daimari for
Respondent number 4.
Learned Council for the respondent number 4. List this matter after
It is after 4th, your lordship.
After 4th.
after 4 weeks.
Lordship, a date may be fixed because.
4 weeks.
No.
After 4th of
After 4th of February.
After 3 weeks, we'll see. Hmm.
Your lordship.
Why?
So there's an urgency.
Why urgency?
So our amount is in the bank of ICICI.
Give that after 4 weeks. Yes, next.
May I please, your lordship?
Interim order passed earlier.
May I please, your lordship? Lordship, with regard to item number 53 and 54, my lordship. My lordship, these matters are with regard to dismiss of default. So my lordship, it may come before appropriate bench if I'm not wrong.
Huh?
Item number 53 and 54, my lordship.
Yes.
These two petitions are with regard to writ petition which was earlier dismissed for default and
Ah.
dismissed for default before by Honorable Justice A.D. Chaudhary, my lordship. So it may come before appropriate bench, I guess, so because since it's dismissed for default,
For restoration.
restoration.
Restoration can be anywhere, any
My lordship,
bench.
there is delay petition, my lord.
Huh?
There is delay petition also along with it.
You think about it. On the prayer of MS,
S.G. Borua.
S.G. Borwa, Learned Council for the petitioner, petitioner. List this matter after 2 weeks.
Then, it has-
Otherwise, there's no bar.
Then, my lordship.
No, you think about it.
No, my lordship, no,
No, you
my
think
lordship,
over
I
it.
thought that.
I'm
it
just
was-
giving you a,
My lordship, then the
no,
matter will
it's
be
okay. I'll give you a chance. Think about it and come back, please,
Oblige, my lord.
after 2 weeks.
May it please your lordship, with the consent of the other side, I beg to mention item number 6, lordship.
Huh?
Kindly matter may be adjourned for 3 weeks, lordship.
Why?
But senior has some personal difficulty.
2018 matter.
Lordship,
What is the matter?
matter. Let's adjourn, lordship, the 2 weeks, lordship. 2 weeks for 2 weeks, lordship.
Why
Adjournment.
2018 matter?
Lordship, my senior has some personal difficulty for.
Okay,
Lordship.
on the prayer of MS,
J. Ghosh,
J. Ghosh, Learned Council appearing on behalf of
S.C. Biswas.
Mr. S.C. Biswas, Learned Council for the petitioner. On the ground that Mr. Biswas has some personal difficulty today. Come on, let this matter be listed after 4 weeks, 3 weeks. You are appearing.
I'm appealing for number 5.
Mr. S.S. Sharma, Argo Swami, Learned Council for Restaurant is present. Yes, next.
Oblige.
Yes,
Lordship, I beg to mention item 41.
yes.
Here I am for all the respondents.
Hmm.
Lordship, I am seeking some time to file a affidavit in opposition.
Mr. On the prayer, Mr. R. Sharma, Standing Council,
F4.
AD, ADEBF. What is this?
Assam. This is the Provident Fund of Assam Tea Employees Organization, Provident Fund.
So ADE,
ATPF. Assam Tea Employees Organization.
ATPF. This matter after 4 weeks. So as to enable him to file affidavit opposition. Yes. Next.
My lord, I beg to mention item number 16
On next thing?
1616, my lord.
Yes.
We received the affidavit from the official.
On the
respondent
prayer
from
of
19
Mr.
A. Goswami on behalf of BD Goswami.
A. Goswami, Learned Counsel, appearing on behalf of Mr. B.D. Goswami, Learned Counsel for the petitioners.
Man, my lord, there's a.
Let this matter be
there's a
listed
interim
after
order as well.
4 weeks. 4 weeks.
2 weeks, my lord.
2 weeks, so as to enable the petitioners to file affidavit in reply.
My lord, there's an interim order. as well.
Interim order passed, and it shall continue.
Always.
22, yes.
Lordship, due to some problem, kindly adjourn the matter for today.
You are for?
Respondent BTC.
On the prayer of MS so-and-so, Standing Council BTC, that this matter be listed after 2 weeks, 3 weeks,
Any date.
after 4 weeks, huh? Yes,
May I please, Lordship? Lordship, I beg to mention item number 24, Lordship.
30,
24.
24, yes.
Case is infectious.
MS, Mr.
R.I. Mandal.
R.I. Mandal, Learned Counsel for the petition submits that the petition, writ petition has become infructuous accordingly. Writ petition states clause on having been become infructuous. Yes,
May I please, your lordship? I beg to mention item number 19. Can this matter kindly be taken some other day, lordship?
on the prayer of Mr.
BB Kapoti.
B.B. Kakoti, Learned Counsel for the petitioners, let this matter be listed after 3 weeks.
Obliged.
May I please, Lordship?
Yes,
Lordship, I beg to mention for listing WPC matter.
huh?
I beg to mention for listing WPC matter
Mention,
for admission.
Which bench?
Bench 4.
Mentioned in the other court.
My lord, in item 5, lordship, it is
Yes.
old pending matter, lordship, 2017. My only difficulty on my part is that I am being led by senior counsel Brinda Grover, lordship.
Huh?
I am being led by senior counsel Brinda Grover in this case. She's the learned senior counsel is having some difficulty today. Can it be in the month of March, lordship?
This 2017 matter.
Yes, lordship.
What is the matter?
I understand, lordship. It's regarding compensation to acid attack victim, lordship.
Yes, we'll decide.
Lordship, kindly
Lordship, in
accommodate.
this case, compensation has already been paid to.
2 lakhs only. 2 lakhs only.
As per new, Lordship,
As
kindly,
per the policy of the
Lordship,
state,
Lordship, kindly
in
pay
terms
to.
of the,
Lordship,
Guy-
I have some difficulty because I learned senior
no,
counsel-
you have already received, if you have received already
But
8 lakhs.
there are some issues which are to be raised by the learned senior
Lordship,
counsel.
kindly have a look at order that is 28/11/2019, my lord.
No, difficulty is, it's an important matter.
Lordship, kindly
We
accommodate.
just
with-
would like to know whether you have taken, comply with the direction of the Honorable Supreme Court.
This honorable court recorded regarding payment, my lord.
Okay.
8 lakhs are already.
It's okay, payment is all right.
Yes.
Beyond that, certain, there is a direction of the Supreme Court and law is in place, whether you have taken, implemented those directions or orders.
That the other pair that has to be fulfilled by government. I'm appearing for respondent number 6 and 7, State Legal Council and District Legal Council.
Yes, yes.
Our part only to pay the compensation.
No, you have paid it as per the rules.
Yeah.
As per the rules,
Yeah.
as per the, what we call it,
Yes.
compensation,
Victim compensation.
victim compensation. So there is no issue so far as
No,
the
Lordship,
payment is
there
concerned.
are some issues which are to be raised.
Yes, I have seen it. That's why we thought we'll dispose
Lordship,
it. of.
can it be in the month of March? Lordship? She is having some difficulty, Lordship. Lordship may fix a date.
Your name is, what is your name?
D dash, Lordship.
Didas, you are,
Lordship, but
what is it? You are,
but I don't have the instruction to do the matter today, Lordship.
Well, then why you were, anyway, although this matter pertains to an important issue with regard to the cases of acid attack, which is pending since 2017, Mr. D. Das, learned counsel for the petitioners submits that he's being led by senior counsel, Mr.
Ms. Brinda Grover.
M.S. Brinda Grover, who is having personal difficulty today. Therefore, praise for turn of the matter to be fixed in the month of March,
Lordship.
which this court is not, would not ordinarily granted. However, the considering that the learned senior counsel has some personal difficulty, as a last chance, let this matter be listed in the month of March, first week of March,
Lordship.
2026.
I'm opposite.
My name will be recorded.
Mr.
M. Mohan for respondent number 6 and 7.
Learned counsel, standing counsel or learned counsel? Learned counsel for respondent number 6 and 7. 6 and 7 is present.
I'm opposite.
The main, the state, who is
Yes.
appearing in this matter? Yes.
Health and Finance Department.
Compensation part is concerned, madam. That pay has already,
Chief Secretary and the Health and Welfare Department.
the
Items
issue of
5,
claiming of some blood scheme by sector.
item 5. Government lawyers, please, learned government lawyers, who is appearing in item 5? It's a very important matter. Just record is who is appearing, Health and Family and Chief Secretary. Yes, why you are keeping? Mr. Record in the so and so. You put in for Health and Family Welfare Department and Mr. N. Das, the State Council for the State Response are also present. Huh? You take a call. Compensation part is over now. Yes, Mr. Das. Yes, next. Why?
As per the direction, we have taken step.
When?
We have the copy.
When?
Yesterday. Due to some difficulties.
Yesterday?
Yes.
The
Matter
office note dated 19/01/2026 reflects that no steps has been taken. Although the notices were issued on 10/11/2025. Mr. So-and-so learned counsel for the petition. Your name, please?
Yes, Chair.
Your name?
K. Kolita.
K.
On behalf of
Kolita.
BK Das.
Learned counsel appearing on behalf PK Das.
BK Das.
BK Das. Learned counsel submits that he has taken the steps for some notice upon respondent number 9 and 10 on 2020. Yesterday.
Yes, sir. Yes.
20/01/2026. In view of let this matter be arrested to verify. And if the steps is taken, notice be sent. List the matter after
4 weeks.
4 weeks.
My lord, the matter may kindly be passed over for the time being.
Why? It's an implement of the, why? New incumbent. Yes. It's a new incumbent.
Lordship.
Yes, it's a
It's
implement.
Implement, Lordship.
Ha,
Earlier incumbent already transferred, Lordship.
ha.
So it is a contempt case. That is why the present incumbent has
So
to.
they'll remain
Yes.
as a party, but these two persons will be, two persons, two
Lordship.
officers
Lordship.
will be implemented. Then we'll issue notice. All right. Heard, Mr.
Decade.
DKD, land counsel for the petitioner, applicant oblique petitioner. And also heard Mr.
T. Anthony, on behalf of D. Nath.
G.
Anthony.
Anthony,
On behalf of D.
on appearing on behalf of G. Nath or D. Nath, land counsel for the respondent number 1 and 2.
1 and 2.
Yes,
1 and 2. Debashish Sharma and Ranjan Sharma, they have already transferred.
No. They are present. They are present. They are the present incumbent, Lordship.
No. Who are the party?
Transfer. Earlier it was Narendra Kumar Shah transferred, Lordship. Deputy Commissioner.
And then how many? Two persons were there.
Earlier we made only one person.
Who was their name? What is
Narendra
their
Kumar Shah.
Huh?
Narendra Kumar Shah, Deputy Commissioner.
You have not met them party here. Appearing for Alice Contemner. Huh? Learned counsel for Alice Contemner, huh? List of next. This is an application praying for implement of the district commissioner, Nagaon, and the state election commissioner
Lordship.
in the office of the Assam State Election Commission as list as contemners in the connected contempt petition number 25 of 2024. This stuff. The applicant has filed a connected contempt petition number 25 of next para, 25 of 2024, alleging violation of what? Order, violation of this court's order. Dated? What is the order of court's order?
But are dated, Lordship.
You have not said anything.
Dated, Lordship, 28/11/2022.
Where do you get it? From where you are saying?
It is, Lordship, in the contempt petition of the earlier contempt petition.
28?
28/11/2022.
28/11/2020.
2020.
Passed in WPC?
Passed in WPC number 5168, 2017.
5168. Please be attentive to towards we're talking there. When I'm asking something.
Lordship. 5168/2017.
5168
68 2017.
2017.
Lordship.
Pity, you have not said anything on neither the order of this court nor the writ petition number. Nothing is there in your application. We're taking up your application only.
Lordship.
Wherein one deputy commissioner, oblique district commissioner, was imputed as Alice contemner, made party as an Alice contemner. Mr. So-and-so learned counsel for the applicant submits that during the pendency, the said alleged complainant Mr. Narendra Kumar Shah, IAS, Deputy Commissioner and Subdivisional Planning Officer, Noga, has been transferred. And in his place, one Sri Devashish Sharma, IAS, has been posted as Deputy Commissioner, Noga. List of, he submits that one Sri Ranjan Kumar, ACS, within bracket, retired, bracket close, is also an necessary party, being the, who is he?
He's the election commissioner.
Who-
State
who-
election commissioner.
who is also, who is the state election commissioner presently? Mr. Therefore, praise for implement of the above two present incumbents in the connected contempt petition. Mr. Next para. Having considered that the earlier incumbent has been transferred from the post of Deputy Commissioner Nagaon, and considering that the present incumbent, present Deputy Commissioner and the State Election Commissioner appears to be the necessary party, being the alleged contemnants, I deem it appropriate to allow this application. Accordingly, accordingly, Sri Devashish Sharma, IAS Deputy Commissioner, 1 and 2, full address, and so, 1 and 2, page 3, are allowed to be implemented as alleged contemptor in the connected contempt petition C number 25 of 2024. I stands allowed and disposed. I stands disposed of. And view of the ordering and contempt in contempt passed in ISO and so. The petitioners to file amended cost title list of on such filing from a registry to incorporate the newly implemented alleged contemptor. List of thereafter notice be issued. The land council to the petitioners to take steps for service upon the newly implemented alleged contemptor. Then in that case, you say here, as alleged contemptor number 3 and 4. Sorry, 2 and 3. He will remain there. 1 will remain, 2 and 3, in the in the IA, allowed to be implemented as respondent number, alleged contemptor number 2 and 3 in the connected in the IA. Okay.
Lordship, kindly, next date, kindly maybe.
That cannot be fixed now. First, you file the amended cause title, they will incorporate, then notice will be, you take steps, notice will be issued.
Obliged, Lordship.
Obliged.
Yeah, you just say notice, thereafter notice be issued, returnable by 4 weeks, huh? Yes.
Wait, please, Your Lordship. Lordship, this matter pertains to unpaid bills, my lord. Pertains to unpaid bills, my lord, of 23 lakhs and 16,000 and some odd change. My lord, in the year 2010, I have supplied products to the Child Welfare Department and they have accepted the product. And when I went for the payments, they have been not paying me the payment for 10 years now, my lord. The affidavit that they have filed, that is also evasive, that did not disclose whether the product that they have received, it was with them or not. That was observed in the order also, my lord, that the affidavit is not comprehensive. Now, my lord, they were about to bring instructions with regard to that.
Who?
My lord, respondent to that will be the Social Welfare Department, my lord.
Where is that observation?
My lord, my first See the order dated 22/6/2022, my lord.
Thereafter, so many
Thereafter also orders has been passed, but this order states specifically that the affidavit that has been filed is not comprehensive, my lord. Otherwise, it is accepted that they have received my product. I have the signatures of my goods being delivered to their godowns. And now the payment part, only that is left over.
that affidavit has not been filed.
They have filed an affidavit, but that's not comprehensive, my lord. That does not fit.
It's asking after that,
Nothing,
thereafter
ma'am.
only
Nothing.
there's an
After-
observation.
After that, nothing has been filed.
Then how many, that was in 2022, who is appearing? Which department?
Social Welfare Department, my lord.
Which for the social welfare department?
Who?
D. Nath, senior government advocate. Call D. Nath. Kindly inform D. Nath.
After some time.
D. Nath, after some time.
May I please?
Yes.
Lordship, may kindly pay this order dated Lordship 1/12. Whereby P. Nayak Lordship Standing Council PWD was directed to receive instruction Lordship on the affidavit filed by the Deputy Commissioner Lordship. Respondent number 3 has already filed their affidavit, so the PWD has to obtain instruction Lordship.
Earlier, Mr. P. Nayak was appeared, madam. Allow me to call him. 5 minutes. So for the sign leave.
What is your case?
Lordship, there are 9 letters of the petitioner's list was taken by the PWD while constructing the drain lodge. So I had
Yes.
for completion under the this one under the Lordship Land Acquisition Act 1994 Lordship. And so the Deputy Commissioner has filed a report that not 9 letters but 6 letters of the petitioner's lands has been acquired Lordship. So on that, based on that report, this one, the PWD has to
So if it is taken, according to you should be paid the compensation.
compensation.
That's your simple case.
Yes, simple.
But instruction I awaited, my lord. 2 weeks time may given.
What this? If the deputy commissioner says so, that it's a land belongs to the 6 letters has been taken away by the public works department and the petitioner is the patterer, then what remains?
To take instruction from the
report.
What remains?
time may given. Time may given. I will take.
What
instruction.
2 weeks? We are directing you to pay compensation, 6 letters. See, your deputy commissioner said so, on oath.
Yes, the report is also there, Lordship, at page number 26. Lordship.
Page number?
26, Lordship. and it's
26.
the reverse, Lordship.
Circle officer.
Yes, Lordship. Page number 26. with the
Different
affidavit
subjects
filed
that
by
have
the
the
respondent.
ownership, trigger
Lordship.
development, it is in the recorded factor of land measuring about 2 feet about diagonal.
The last paragraph, Lordship.
Betapara. It's a Patta land. You are entitled for compensation.
Yes,
Are you? Under which law?
Lordship, under the provisions of the Land Acquisition Act 1894, Lordship,
There was no acquisition.
there are no.
What would be 6 acres? How much would be this area? I mean, 144 square meter.
12 feet by 12 feet, that is 1 lisha.
Ah,
So no notice was-
144 into 6 lordship, 600. Sorry,
square feet.
6, 7, 8.
See, drainage system is also public, it's for public only.
But no notice was served, Lordship.
Huh?
No notice was served, Lordship. Without following property procedure, Lordship.
Of the PWD, and there is no such any acquisition request from their side. That is reflected in our affidavit.
This is affidavit. No, report says so, page 26 clearly. Has been utilized by public works roads.
Comes to page 29,
Hmm,
annexure B.
hmm.
That black mark portion.
Yes.
That belongs to the petitioner, and that dotted marks,
Ah,
that is under the occupation of the, that small portion, lordship,
hmm.
is under the occupation of the PWD.
No, no, how can you say that?
From the trace map, lordship.
You have already taken.
yes, yes.
Therefore, it's a no.
No, I am for the deputy commissioner.
Now it's not on the occupation of the PWD. It has been taken from the petitioner.
Yeah.
Then you have, the PWD has constructed the road, I mean drained. Yes. Was appearing you. You are a standing council. What directing you pay in accordance with law?
1 week time may given, my lord. Have
1
you received
week.
this 1 week, my lord?
Then in that case, had MS so and so learned counsel for the petitioner. This court, having noticed that the petitioner is the recorded pattadar of the land measuring about 2 kata covered by diagram number 2433 of KK Patta number 2537 of village Borsozai under Beltola Moja. And as per the report, 6 leches out of the land of the 6 leches, and as per the report, an area of 6 leches has been taken by the public works within bracket roads, bracket close department, has been taken from the petitioner in order to construct a drain. Mr. P. Nayak, Land Standing Council for the PWD, was directed to obtain instruction as the same was in terms of the affidavit in opposition, in terms of affidavit filed on behalf of the Deputy Commissioner.
District commissioner.
District Commissioner, Lister. However, today, MS MDAS London Standing Council, PWD, 6 weeks time to obtain instructions as granted by this court on 01/12/2025. Lister. Considering that a clear instruction from the Department of Public Works has required. Come on. A week's time is spread for by legislative council is granted. List a matter after a week.
Lordship may fix a date. Lordship may fix a date.
Madam, it will be listed, don't worry.
Leonis.
Oblige.
Wait, please, your lordship.
Yes.
Lordship, in this case, Milord, the forceful taking of my vehicle, Milord, by the finance company, Milord, is the subject matter of this writ petition. After taking of the vehicle, Milord, we preferred a writ petition. In the writ petition, Lordship, notice was issued with a direction to us to pay rupees 1 lakh. We complied with the direction. We paid rupees 1 lakh. They accepted it, Milord. Thereafter, now they say, Milord, that the vehicle has been sold. Thereafter, many attempts for reconciliation were done. That was also not, Milord, with any fruitful result, Milord. In these circumstances, we are before your lordship for compensation, Milord. Basic tax, Milord, is this, Milord. If your lordship takes up the writ petition, Milord,
No, what is your stand?
they have not filed any affidavit, Milord.
Are you
Since
ready?
2020.
Are you ready for the?
My submission before Lordship,
Yes.
although I could not file an affidavit, what my brother said is actually correct. Because Lordship, the respondent office is now under liquidation, Lordship, and they are having only one staff. And he is not having any power of attorney. Now the maintainability of this writ petition is, I am just pointing out the maintainability, Lordship. Because Lordship will kindly see that we have a contract with him. As per that contract, if he default, we can take possession of this vehicle. So he defaulted, Lordship, and today also their default amount, Lordship, is around 1,83,000.
Now, is it a contract, terms of the contract that in the default, you'll sold off the vehicle?
He was intimated.
Forcefully taking of the vehicle.
Forcefully taken up, Lordship, they have lodged an FIR. And I have been intimated by my respondent, state respondent, that an FIR has been filed in that. So there is nothing at all. No
In that-
election of the state.
In that case, you approach the civil court.
No, lordship.
It's
Yes,
not
doc-
all the cases cannot be filed in
Milord,
the
it is
decision.
doctrine of election comes into play, Milord. Doctrine
No,
of election is when lordship may hear me, Milord, then lordship may
No,
decide
no.
it, Milord. I have no difficulty with that, Milord. If your lordship direct, we can go to the civil court, but after 5 years of litigation in the high court,
Somebody
sending back
who has
the-
raised, it was raised in the initial stage. Anybody raised the maintainability?
He has not filed an affidavit. But if my brother is ready for the hearing today,
Aye, Milord.
my point is on
With
the
regard to the
maintainability of this writ
maintainability
petition.
also, I can satisfy your
Because Lordship,
Milord,
there
on
are
that
a lot
matter.
of judgment that if there is an alternative remedy, then that
You
should be
cannot
first.
do that after the doctrine of election. After you chooses to accept 1 lakh, Milord, by the order of this court, Milord,
That my.
Let us
should
see
be
the
kindly-
order of this court.
16/12/2020, Milord.
16,
12/2020, lordship.
So let them produce the money receipt, Lordship. My
16,
instruction
12.
is
16/12/2020, lordship. First order, very first order, lordship. 16/12/2020. Lordship has not. But so and so the grievance for the petitioner is that the vehicle purchased by the petitioner with the financial assistance from respondents was illegally taken away on the alleged ground of default in payment installment. Mr. Das submitted out of the total loan amount of so and so, only a sum of 7,21,000 remained to be paid. Due to COVID situation, the petitioner could not generate the money. The land council submitted that his client is ready and willing to pay the balance amount if some reasonable time is granted. Once the petitioner has prayed for an interim order directing stay of the action. Under normal circumstances, this court would refrain from entertaining such dispute in writ petition. However, keeping in mind the unprecedented situation arising out of the outbreak of the pandemic, I am of the view that a prayer made by the petitioner deserves consideration. The same can, however, be made only after service of notice upon the respondent. In view of the above issue notice, it was so and so, Mr. Bhattacharya, learned additional senior
It's
government.
already indicated,
so-and-so.
there.
Lordship, second page, the petitioner to take steps so and so 3 and 4 by registered post ready.
Willing to pay the balance amount if the vehicle
Petitioner is
is sold
permitted to take
the
notice by justice so and so, heard on the prayer of interim relief. Mr. Das submits his client is willing to pay the balance amount if the vehicle is restored to the said prayer will be considered on returnable. However, as an ad interim measure, it is provided the vehicle belonging to the petitioner shall not be sold in auction till the returnable date, subject to the condition of petitioner deposit rupees 1 lakh.
There's no question of doctrine of election coming to press into
Yes,
survey.
they accepted
See,
1 lakh.
no, it's a direction of the court.
Yes.
Can they say that, no, I will not agree, will not take it?
Milord,
Can they say
when
so?
the court, I have been put to a
No,
documentary
I think,
Can the order
perhaps
of-
it's a misplaced. You are trying to,
Milord, one way, Milord, I have been directed to pay an amount which
therefore you have paid. Then
Therefore, I
before
have
that,
paid.
you have read it. Normal circumstances, this so far where today where that part is over.
Lordship,
Because of the COVID situation only,
Lordship.
it was,
So
a notice was issued.
notice was issued.
And you have agreed to pay the balance amount.
Lordship.
There is a direction.
That is right.
Can they say that, no, there's, even if there is direction, we will not accept it?
They
Can they
could
say
have
so?
come to the court and said
It's a
that.
court, no.
No,
It's
they
not a
can-
question of saying court. Court can, court
When
has
the
directed.
order of the court.
It's not an election, it's your assurances that court has directed. Though you are ready to pay.
Lordship.
It
Now,
clearly
Lordship-
says, under knowledge and this court would refrain from entering such dispute in a writ petition.
Now, Lordship, the
There's
question.
no question of election. It should be, I mean, sheer wastage of time of hearing both the council. It's better. You go to the civil court.
Lordship, I have a case.
This already, so don't try to, I mean, this thing,
Lordship.
which is not, I mean, relevant.
Miller,
I know the doctrine. See,
Lordship,
please assist.
Lordship. No, my only question is, Lord, when doctrine of.
You, sir, you appears to be seasoned lawyer. Please assist the
Lordship.
court.
Lord-
Therefore, this has clearly indicated.
Lordship.
I was wondering, what is the question of a doctrine of election?
Doctrine of
Doctrine of election will be got if
In
they have
the
done it
agreement
on
of-
their own volition, right?
And
That
Lord-
you pay this, I will accept this.
Lordship.
Now you cannot say that.
And
Then
Lordship,
you
that-
cannot solve it.
Lordship.
Put it in auction,
Lordship.
right?
If I agree with
Now-
Lordship commission.
Now-
sorry,
now-
Lordship contention also.
Now this is a direction of the court. They are
Lordship.
bound to agree, right?
And Miller, the
See,
second principle of law would be, Miller,
what?
that act of the court should not prejudice anyone.
No, that also
That should
again,
also be a
another,
principle of law.
another misplaced, I mean, the understanding of the doctrine again. Because
Lordship.
this petition was entertained and notice was only issued in the peculiar circumstances that due to COVID.
Lordship. For a moment, let us assume to be correct.
Because of the pandemic only, because it has been clearly
Now,
recorded.
because the
That's what I
pandemic-
was wondering
Can-
also.
Can the court?
I was
turn the
wondering
clock
that
back,
such a
Miller?
petition can be entertained.
Lordship.
In fact,
No, it's turning the clock back.
so this has already been
5
recorded.
years, Miller, it has been 5
See,
years.
you have read it under normal circumstances. Now it's a normal circumstance.
Now it is the normal circumstances.
Therefore,
but, Miller,
I
can-
advise you to approach the civil court. You have not been rendered remedialess. You have
Miller,
obtained numbers of forums,
the vehicle was
obtained
taken.
numbers of forums.
Maybe. Miller.
It is as
Only-
per
only
the, you
submissions-
have the contract.
Two submissions.
You have the contract.
Lordship, two
Please.
submissions, Miller.
Try to
One,
understand.
Lordship, take it on 27. I will satisfy your Lordship on that.
No,
I will
no.
take 5 minutes, Miller, on that.
If-
Your Lordship, hear me today itself, Miller, I will satisfy your Lordship.
No, no,
Yeah.
it's of no use. Because there's a,
Lordship has to
There
hear
are-
me, Miller, after
see,
7
what?
After 5 years. Miller,
Sir,
6 years, Lordship.
Because
Kindly,
it
Miller,
is you
hear me
and
on-
the parties who have, I mean, kept it pending.
Miller, no, Miller.
Whom you are blaming?
I am not blaming it anywhere. I am saying
Then
the matter.
you have blamed yourself.
Lordship,
You
the matter
has
has been-
allowed it to remain pending for 5 years.
Miller, the responsibility comes to everybody, Lordship. It
Sir,
cannot be my sole
You
responsibility.
have read it on 16/12/2020.
Lordship.
It has been, it has indicated by the
Miller,
court.
certain, Miller, there was time for amicable settlement was there. They have not filed affidavit till date, Miller. Any affidavit, let them bring anything on record, Miller. There is
Lordship, I have
nothing
put
on
this
record.
statement of account, Lordship,
Let them bring it on record.
which
Lordship.
says this statement of account is till 2/4/2025. And this statement of account says, Lordship,
Mr. He is not trying to understand.
Eh,
SK
Lal.
Das.
Lal, Lordship.
Lal, sorry, London Council for the petitioner. Upon consideration of the grievance raised in this petition, which previously appears to be civil dispute, purely of civil dispute, which to which this court is of the previously view that the
May I hear me?
maintainability of the writ petition. Which this court is of the prime facie view that writ petition may not be maintainable. However, considering that the respondent authorities has not filed any response, further 2 weeks time is granted to the London Council, Mr. A. Bhattacharya. London Council will respond number 3 and 4, as well as Mr. Okay. We file affidavit in to file response, huh? The maintainability of the writ petition shall be considered before
On 10th of February,
entering into the merit of the matter.
10th of February, Lordship.
No, before that.
Lordship, any date.
Any date.
Lordship, tell me. Any date, Lordship, fix me, Lord. Only 2 to 1st week of Milord, I am not available in Guwahati, Milord.
You are from Delhi,
No, Milord, from Guwahati, Milord.
then,
I am matching Arunachal Pradesh on 4th, Milord, 3rd and 4th. Milord.
huh?
3rd and 4th, I have been Arunachal Pradesh, Lordship. So,
So in 2nd February,
second.
Second Lordship, there is some, can it be on first or third Lordship?
third, he is over.
3rd, Milord, difficult. 3rd, I will be traveling, Lordship.
Three,
So there is
you
a-
will be there, na?
Yes.
So make, let us
2nd, I
make,
have no difficulty.
let us make it on 5.
5, I will come only on 4th.
Six.
6,
Six.
Lordship. Yeah.
You file the
Fifth or
affidavit, including the raise the maintainability also.
On 6th of.
Lordship may kindly just absolve this.
And please, he has tried to, I mean, press into service the doctrine of what?
Doctrine of election. Lordship.
Election
That is
and,
right. We are-
and
Lordship, let me reply, Lordship. Doctrine of election is only in respect of the documents.
don't say, don't say that.
Yes,
I'm
sir,
just
it's not
indicating.
correct.
And then other one is the principle of the maxim that the
The order of the court should not prejudice anyone.
prejudice anyone, right?
Lordship.
If you don't convinced
Lord,
this court,
Lordship.
will impose you cost.
Lordship. And if I
Not on
convince
the
Lordship to
petition, not on the
ever
petitioner,
adequate
on,
compensation.
not on the petitioner, on Mr. Lal.
I will pay to the legal service, Milord, whatever fees Lordship grants, Milord, I have no difficulty with
Not
that.
less than 5
And
lakhs,
I'm not a
not
poor
less than
advocate,
5
Lordship.
lakhs,
I can-
Mr. Lal.
Lordship, I agree with that, Milord.
Excuse me,
difficulty.
for 10 minutes.
Lordship.
I just have one.
I've
fair
some
Lordship.
personal, I mean,
Just one. fair
difficulty, just wait.
Okay, okay.
10 minutes.
Certain.
Lordship.
Just 2 minutes.
Yes, sir.
In the other.
No, it's okay.
But here,
But this, since it's pending 2016, so we cannot afford to just, I mean, adjourn like that.
well, here in this case, they have claimed for an amount of rupees 23 lakhs for some supply. The affidavit has been filed by the director denying that some order was issued in their favor. It is an order given to some other. Ultimately, the amount is not admitted. That is the stand of the department, Milord, that kindly take the affidavit of the director, Milord.
No, there was a direction, I mean, observation by this court that the affidavit filed by the respondent number 2, that is, you are relying on that. That same does not disclose the entire facts insofar as the claim made by writ petition is concerned. Situated that respondent number 1 is directed to file comprehensive responding to claim made in writ petition.
If Lordship kindly takes up the affidavit.
Page. Affidavit filed by. Yes.
Some, let me read, Milord, paragraph 4,
Yes.
Lordship. The matter relates to non-payment of bill amounting to rupees 23,16,369 only in respect of Rupai Development Organization during for supply of SNP in Panitola ICTS. It is to be mentioned that the file that what is missing, Milord, number so and so DSWG 23/2019 has been seized by the Vigilance and Anti-Corruption Department as per relevant documents, records available in the file bearing number so and so. It appears from the government wide letter number so and so dated 19 June 2009 as per government notification number SWD.25 so and so dated 19th of March 2009. The select list of NGOs for implementation of SNP scheme in the Anganwadi Center under General Areas ICDS project, the name of the NGO, that is Rupai Development Organization Tinsukia, was not selected to procure the SNP foodstuff or the year 2009 to 2010. Hence, the question of allowing the formal work order to NGO could not arise since the organization is not empaneled during the year 2009-2010. They were not empaneled, number 1. Again, The work order provided by the petitioner mentioned at paragraph 3 of the writ petition, the deponent states that it was originally issued in the name of Pravati Welfare Society by letter number so-and-so dated 18/3/2010. Hence, it appears that there is no such work order was issued in the name of the petitioner Rupai Development Organization, Tinsukia. In this connection, this directorate called for hearing of the CDPO Panitola and the Secretary Rupai Development Organization on 28/8/2018, and accordingly they attended the hearing. As materials on record and statements along with the relevant documents submitted by Dilip Srivastava, Secretary Rupai Development Organization, it is revealed that the signature of the Director Social Welfare Assam shown in the work order so-and-so is dated 3/11/2010 is fake. They denied that that order is a correct order. In fact, my respectful submission is therefore that whatever claim they have made, these are disputed, ultimately.
Is it fake or not? What is the, whatever?
These are disputed facts. They have to go to the civil court to substantiate their claim, not in the writ court.
Lordship, if I may submit. Lordship, the supply was done in the year 2010. 2018, they form a committee and they see that what documents were given and what is
No,
taken.
no,
what is
then now
not.
it's become
But my
a,
lord,
see,
in
you are
2010
claiming is for what?
My lord, I am claiming for the goods that I have supplied and they have duly accepted it. The acceptance is also there, my lord. on record.
Ultimately what? You want the payment,
Yes, my lord.
your direction to pay.
Yes, my lord.
You want that we should issue, this court has issued a direction to pay this amount which you have claimed.
Lordship,
Now they are disputing it.
Lordship,
you-
you are not disputing the acceptance of product. They are disputing that now.
No.
My lord,
It clearly says, you have read it, they have said it, the amount, I mean, the work order which you have, on the basis of which you are claiming the bill and supply, they said that
happened in the year
no
2000.
supply order work order was issued in your name.
This happened in 2018 when they formed a committee and they diagnosed it and they thought that now this.
Can do.
My lord, at the time of payment,
No.
10 years later, now you come and say that now that was fake. But my lord, if comes to page number 17 of my writ petition,
Huh.
there's an acceptance and it says by the Child Development Project Officer that is certified that the food items has been received in good condition and fit for human consumption.
No,
In full
whatever
quantity.
may
My
be.
lord, there is no denial with the fact that my products were not delivered and they are not used.
No, it's not a question of that. Question is whether they are accepting it or not. This
lord-
amount which you have raised.
My lord, if I may add here, Section 70 of Indian Contract Act says, my lord, obligation of person enjoying benefit of
See,
non-gracious.
how you can, how do you, when when you have not been, the issued a work order, how you can supply? Who will accept this? Who is the authority?
My lord, I may say that records may be called in this case, my lord.
It's not a question. It's a
My
simply
lord,
you are,
this pertains to
what is the issue?
my lord,
Issue is what?
payment of bill that I have
That's
supplied
all.
a product.
The law is very clear. It's a very simple law. If it is admitted, we may direct in under the writ jurisdiction. Writ jurisdiction.
My lord, there is no denial on the part.
Exercising writ jurisdiction, we can direct them to pay.
Very well, my lord.
Now, once it is disputed, you have not been, rendered remediless, right? And you have waited for since 2010. When you have supplied in 2010, you
Right.
have waited for 5 years.
No, my lord, we have given our representations in the meantime.
It's
and we
okay.
waited for the.
There is a
authorities
law
to act
also
upon.
that the representation after representation will not allow your cause of action.
My lord, this is a two-limb situation here, my lord. They deny the
No,
order.
no, once it is a case of payment of outstanding bill, claim for payment of direction to pay, payment of outstanding bill, once the authorities denies, clearly saying that the work order has not been issued, you might have supplied, right? It has to be in accordance with the procedure. The work order has to be issued to you, right?
My lord, as much I have gone into the law of this point, my lord, with
Huh.
regard to non-gracious acts of supplies, my lord. It always says that quantum myriad, the doctrine of quantum myriad, it says that when a person has
It's a law of contract. It's not a law of contract.
my lord,
Contract were not on that. This is you have approached this court.
my lord,
right.
they're not denying that my goods were not supplied. They're
Huh?
saying that order was fake. They're saying that today, after 10 years, when they formed a committee.
Then where remedy lies? That's what I'm saying.
But my lord, what about the products that I have
Your
supplied?
doors are not shut. Provided you can say, establish under the law that it is barred by limitation. And there's a optimum number of case laws, I mean, decision of this court also. If there's a delay in, I mean, if the, under the law, the claim is barred, we cannot entertain in a writ jurisdiction for such a claim for outstanding bill amount.
Then lordship, may kindly grant me some time to satisfy my lords on the limitation part. If my lord is going,
Huh?
then grant me some time to satisfy my lord on the limitation part. my
Not
lord.
limitation here, right? Limitation will be when you move the court,
Civil courts.
civil court. I mean, you may apply you have filed the writ petition in 2016.
16, my lord.
Then you may invoke, seeking invocation of
Section 14 of
section 14 of the limitation act,
Yes.
right?
Pendency
I
of
think
suit.
we'll give you a liberty. It's of no use. Otherwise, we may not give that liberty also.
Then, my lord,
Once
to-
you
today,
decide
if I
on
may
merit.
pray, today, if I pray, my lord, my lord,
What's there?
no, my lord, if I may pray, let me go back and I will consult with my client what they intend to do. If there is that they
It's
want
not
to
your
pursue
plan,
the
it's
civil
you.
courts, my
You
lord.
are this, I mean,
Because my lord, going to civil court again,
you
I
have,
have,
huh?
again going to civil courts and
Otherwise it will dismiss.
my lords may grant me one opportunity, my lord.
What opportunity? This 2016, that's why I requested Mr. Nath to appear.
Lordship may take it up on 27th.
Despite he being busy in the
My lord, on
other courts.
27th, my lord.
It's a very simple.
I understand, my lord, but
On this issue, law is very simple. You argue, then I'll decide.
on 27th, my lord, then I'll pray.
We're fixing on 27th for withdrawal.
No.
If you want to argue, you argue today.
My
It's
lord, I am
2016 matter.
I am on the point where they have accepted my goods and I have judgments with me, my lord, that satisfies, my lord, that once the goods has been supplied and then they have enjoyed it, now I am obligated to get the payment.
In the case of
MTNL, my lord.
huh?
MTNL versus Tata, my lord.
Huh?
There's a case law, MTNL versus Tata. It specifies that if the goods that has been serviced or is any service that has been rendered and there has been a contract, now if they come up and say it is fake also, but the goods have
There's
been
no
enjoyed,
contract. Problem is there's no contract.
my lord, that they say today is fake, my lord. After 10
That's
years,
it.
my lord, they say that it is fake. But at the time of procuring the products and using it, that time they did not come up with this fake thing. No.
We're not supposed to. Only what we have to see is whether the bills are admitted or not. That's all. If it is disputed, you avail the remedy under the law. That's all.
My lord, I supply the goods, they accept the goods. When I go for the bills, they say that the order is fake. My lord, they have accepted the goods, they have used it, my lord. Those acceptance letters are there with me.
You're relying on 2019 5 SCC,
My lord,
MTNL,
yes, ma'am.
Tata Communication.
Yes. Mahanagar Telephone Nigam Limited, my lord. Here also, if I may read, para 4,
Huh.
that says 70 obligation of person enjoying benefit of non-gracious act, where a person lawfully does anything for another person or delivers anything to him, not intending to do so graciously, and such other person enjoys the benefit thereof, the later is bound to make compensation to the former in respect of, or to restore the thing or done, or deliver it back. They could have delivered back the good, saying that it is fake, but they have enjoyed it, my lord. And relying on these judgments, my lord, the court has reasonably passed orders where payments have to be made if the goods are accepted and they have been services have been rendered. But in my situations, both have been done.
See, you are clearly says if there is a very seriously disputed question of facts which are of complex nature and require oral evidence for their determination. Number 2, money claims particular arising of the contractual level are normally not to be entertained except in exceptional circumstances. There is no exceptional
My lord, in their
circumstances.
affidavit, they
You
almost
claim that you have supplied and some officer has accepted it. Now they are saying that your work order itself is a fact.
but they do not comment anything on the part of acceptance of goods, my lord.
There's no circumstance, there's no exceptional circumstances.
My lord, 27th, my lord. On 27th, I'll say this one.
You are good now.
Cover.
I'll give you 15 minutes. Argo.
No, my lord, 28th, my lord. I'll satisfy my lord on 28th, my lord.
Today. We have spent around 20 minutes.
At 2, my lord.
Huh?
At 2, my lord. Well, lord, I'll just consult with the client also with regard to if there is some civil remedy he wants to exercise or not in this matter.
Huh?
It's 10 years old matter, my lord. I'll just consult with the client also.
Not 10 years. Huh.
Now, according to him, he supplied in 2009-10.
Yes.
By the time when you file this writ petition, it's also barred. What is the limitation?
My lord, 3 years in accordance when it comes to monetary issues. My lord, we are way past those things, my lord. My
So
lord.
that is, it's I mean, since you cannot file a civil case, it is barred by law. Therefore, you want to get the things done through the writ petition, writ jurisdiction.
No, my lord,
That
that
is
was
not
not the
permissible.
intent, lord.
Anyway, since he's insisting, I don't
My
want
lord,
him to
on
be
27th, my lord, or 28th, my lord. I'll play.
dejected today.
Oh, my lord, 28th, my lord. Kindly take it up on 28th.
I don't want to get himself dejected. Last chance,
28th, my lord.
28.
All right.
No further adjournment, right?
No, no, my lord.
On the prayer of Mr.
Jay Singh, my lord.
Jay Singh, Learned Counsel per day. Your name is Jay.
My lord,
Your name is not there. Jay Singh, Learned Counsel, appearing on
on
behalf
behalf of Mr. V.D. Kaur, my lord.
Mr. B.D. Learned Senior Counsel. And as agreed to by Mr. D. Nath, Learned Senior Government Advocate, that this matter be listed on 28,
28.
01, 2026 as a fixed item, a fixed matter. As the matter is pending since 2016, which pertains to claim of payment of outstanding bill amount for supply of what? SNP
goods, my lord.
SNP goods in the year 2009 and 10.
Well,
I'm indicating all this.
Yes, ma'am.
There's a reason
Yes.
to make you more, wise.
My lord, if I may.
As a last chance, huh?
Yes, my lord. Well, 27th, my lord.
Not 28.
Not 27th, my lord.
28.
27th,
27 were fixed.
27th, I'm free.
27 were fixed, so many fixed matters. Not be possible.
Lot.
28.
8 is comfortable. Lot. All
You kindly, arrange accordingly.
Yes, ma'am.
All
Item 13.
Yes.
One of the subject matter of this writ petition is, my lord, challenge to an order of the Register of Cooperative Societies by which my appeal has been rejected. The prayer was that, my lord, the registration of the private respondent cooperative society should be cancelled because they had drawn members from our society. Now, my learned friend was saying she has not received the affidavit of the Eastern Register of Cooperative Societies.
Who are you?
Lordship, I'm for respond number 5.
Who is respondent number 5?
The private respondent, my lord. So under the High Court rules, my lord, even the respondents are entitled to have the affidavits of other respondents.
You are for.
So let it be served, my lord. Let it come some other day, my lord, as per convenience of lordship, tomorrow or any other day, my lord.
Tomorrow is not possible. Okay, and Mr. M.K. Chaudhary, learned senior counsel assisted by
Yes, count.
S. Count, learned counsel for the petitioner. Petitioner. Petitioner, huh? The MS expert, A. Talukdar, learned counsel for respondent number 5. Submits that she has not been furnished with the copy of the affidavit in opposition filed on behalf of the Register of Cooperative
No,
Society.
additional raise, my lord.
Anyway, on behalf of the
Assistant
this-
Register of Cooperative Society. Respondent number 4.
Assistant Register of Cooperative Society, who is being represented by Mr. G. Bordole. Is that council or standing council? Registered Corporation, standing council, Corporation Department. Mr. Bordole, the standing council undertakes to furnish the said copy to the land council for respondent during the course of the day. In view of above, let this.
May I also
matter
point
be-
out, my lord, the Register of Cooperative Societies who has, my lord, passed the impugned order, he has also not filed any affidavit. And the private respondent has also not filed any affidavit. If they take time, let them take time today, my lord.
Then you file whatever is there.
File it, Lordship, file it.
List of
So that there is no
Uh,
further adjournment.
it is noticed that no affidavit has been filed. No affidavit in opposition. No affidavits on behalf of the registered cooperative societies
Yes, fine.
and for a respondent. Comma. 3 weeks time, further 3 weeks time is granted to both the respondents to file their respective affidavits. List the matter after 3
Your
weeks.
lordship may kindly observe, no further time will be granted. My lord, this is a 21 matter, my lord.
It's okay. 21.
Obliged.
License.
If you want fixed date, we'll give the fixed date, but you cannot say that. That after 3 weeks, if you want it, if you want a particular fixed date, we can
Yes,
give
my
you
lord,
that.
that will be helpful.
After 3 weeks, just give. After 10th, huh? After 10th.
Obliged.
May it please your lordships. Lordship, before I recapitulate the matter to your lordships, if your
Yes.
lordship would kindly peruse the order dated 29/1/2025 passed by your lordships.
29?
29/1/2025.
29-1. Yes.
If I may read, lordship. Considering that the amount of rupees 55 lakhs of the petitioner is retained without the fault of the petitioner, and despite the liberty granted to the respondent bank to refund wide order dated 7/8/2024, the respondent bank has failed to refund the said amount. And also considering the observation made by this court earlier, Ms. S. Das, learned standing counsel for the Industrial Cooperative Bank Limited, is granted 2 weeks' time to obtain instruction as to why the bank should not be directed to refund the amount of the petitioner forthwith and pay an interest at the rate of 8% per annum with effect from the date of deposit of the said amount to the respondent bank. Now, my lord, after this order being passed by this honorable court, a different bench of this honorable court had implemented the state government, the corporation department, and the officer on management of the Industrial Cooperative Bank as respondent numbers 3, 4, and 5 in the instant writ petition. Reason being that there was no board of directors of the bank functioning at that point of time, and the state government was operating the bank.
Yes.
As on date, lordship, the board of directors has already been constituted by the bank, and the state government is no longer required to be a party to the instant proceedings. And so far as the Industrial Cooperative Bank Limited is concerned, respondent number 1 and 2 They have already filed their affidavit in opposition. They have already filed their additional affidavit also, and we have also filed our rejoinder. So the pleadings are complete in this matter.
So,
The basic gist of the matter, Lordship.
no, however, this, we cannot again review this order. By
Not
this
really,
order,
Lordship, but
by 9/5/2025,
yes, Lordship.
they have already been implemented.
Yes, Lordship.
Let them say, what do you say?
For 3, 4 and 5.
Who newly implemented? What is your what is your stand?
Lordship, it's been since May till January now.
No, this 25, which order you have read?
I read 29(1).
29 is also not been modified.
Yes, Lordship.
And in the meantime, this 9/5/25 has also not been modified.
Yes, Lordship.
So I think we should grant them some, whatever they want to say, let them say.
Since May 2025 till January 2026.
Yes.
They have been praying for time.
Which will just give a last chance.
Last
Whatever
Lordship,
they want to,
statement
they want
will
to
be
say, let us hear them.
Lordship, a last.
Because we just cannot sumoto review our own case.
Lordship.
I mean, own order.
So,
It will amount to review.
yes, Lordship. So a last date a date may be fixed for the matter.
Do
Because
you have any instruction? Do you have any idea? What is your, could your
Lordship,
stand?
they had initially placed instructions. Mr. Talukdar was directed to initially place instructions, and thereafter they were implemented as respondents.
Yes.
And when the instructions were placed before this honorable court, it was nothing but a repetition of whatever has been stated in the affidavit in opposition filed by the bank.
Are you blaming the court?
No, Lordship.
Despite that, we have allowed the implement the respondents.
Lordship, implement I'm not blaming.
Yes.
The implement was made on the basis of the instructions placed by the Corporation Department. My only humble submission is the instructions which were placed by the Corporation Department were exactly the same as what had been
Madam,
brought
all
to
this
record.
observation will remain. Let
Lordship,
us see, since there is subsequent development, I think hope the coordinate bench has taken note of all these orders also. So let us see.
Lordship, I just pray that a fixed date may be given because on 1st
Yes,
September,
we'll
3
give the
weeks was
fixed,
granted.
don't worry. Her MS,
Dr. P. Agarwal.
Dr. P. Dr. P. Agarwal. Learned counsel for the petitioner. On the prayer of
SK Talukdar, Corporation Department.
so and so, learned
3, 4 and 5.
appearing on behalf of S.K. Talukdar, learned counsel for Corporation Department.
None has
A
appeared.
last chance of 3 weeks is granted to file affidavit on behalf of the Operation Department. List the matter after 3 weeks. Give the date. 18 February.
Deeply obliged, Lordship.
It's the list of 3 weeks. On 18, huh? 18 February. 18.
Item 18.
None appears for the petitioners on call. Mr. So-and-so.
And the state government.
For one.
One, so-and-so, two. Are present, huh? It is noticed that on 10/11/2025. Also, also non-represented the petitioner. Next para, upon consideration of the grievance raised, which is to the effect for payment of compensation, which alleged to have been mutated in the name of the petitioner. Well, the mother is alive. It appears that the petitioner is no longer interested to pursue the matter. According to the instance, dismissed for non-prosecution.
Item 21. Given number.
Item 21.
No affidavit.
No affidavit.
My lord, in this, my lord, the NRC's party here is actually, I had not been sought for the in this case. My lord, may I pray, my lord?
NRC, what NRC? Rent amount of rent which the as per the lease did so and respondent took the premises on rental basis to include the work, but failed to pay the rent. What copy is required? You have no fund now.
My lord, my name may be shown in the matter may
You
come
have
out
no
of-
fund. Have you taken on rent?
Yes, no.
My lord, I
Taken the premises?
no, my lord, I have no, my lord, actually, I have come to know about the case just now, my lord. That's why I don't have the information.
Take instruction. We'll fix
Yes.
it on 29. Fix it on 29. Take instruction. If you have taken, whether fund, no fund,
29.
huh?
My name may be shown, my lord.
Heard Mr. Escoto Land Council for the petitioner. Considering the simple nature of grievance raised for payment of rental, which has been taken on account of the premises being taken by the NRC for NRC process. What is NRC process or something? The NRC updation process. Mr. J. Pang, Land Standing Council, NRC, to obtain instruction, list the matter on 29/1/2026. Black and white,
Yes, my name may be shown, my lord.
registered to reflect the name of
Standing council NRC.
Standing Council NRC in the cause list.
May it please, your lord.
Yes.
This is regarding my lord, payment of compensation. For acquisition of land, my lord. No affidavit has been filed till date, my lord.
Yes,
Lordship, may I pray for some more time, Lordship? We have not received any instructions, Lordship.
heard Mr. Katinia, M. Katinia.
NJ Khatri.
Sorry, NJ Katinia, Land Council for the petitioners.
Yes, my petitioners.
Petitioners. On the prayer of Mr. H. Sharma and Mr. D. Bora, Land Standing Council.
NHI.
You are
Appearing on behalf of Standing Council, NHI itself, Mr. R. Bora.
the council for the respondents. For the 3 weeks time is granted to file affidavit. Affidavit in opposition, right?
But, the affidavit as opposition has been filed, we have filed a reply. It has come for admission, my lord. I pray for taking up the matter after a week.
For
For
hearing,
for disposal.
We'll fix it for hearing.
Lordship.
Will you admit the petition?
Lordship, that will, my lord, that may go long. my lord.
What is the matter?
At the admission stage, my lord, can be considered. my lord. At the admission stage, my lord, lordship. may
What is
consider.
the matter?
Lord, the respondent number,
Between the,
lord, the
Are you a petitioner? Are you a petitioner?
no, I am the respondent number one, my lord.
Then he'll
Yes,
be
my-
deprived.
Yes, my lord.
So let him.
the respondent number
Right.
one, the impugn communication of the respondent number one, by which, my lord, they have forced us, that is at annexure 21, page 82. By that, my lord, the petitioner was forced to deposit 1 crore 56 lakhs, my lord. And otherwise, they said that if we don't deposit that particular amount within a time frame, they will encash the bank guarantee. And we have deposited the amount, my lord, page 85 under protest. That is the action on the part of the respondent number one.
You are challenging that.
We have challenged them.
Yes, under what authority? Under the contract.
There was a contract between
As per
the,
the contract.
there was a contract between the respondent one and the respondent number two.
Yes.
The respondent has joined with him. Joint venture for completion of the contract.
Hmm.
my lord. They worked in the same entity. my lord. My lord, what happened? There was some delay in doing the works. They were not doing the works under the contract. So we cancelled the contract. So thereafter, the respondent number two, who was the primary contractor, he got the matter referred to arbitration. So there was an arbitration proceeding and there was an award. And by way of that award, he claimed the entire machineries which he had hired from him also. The arbitration was awarded in favor of the respondent number two. And thereafter, there was a settlement arrived, whereby one-time settlement, one amount was paid for consideration of the entire award. The entire award was settled. And in the meantime, before that settlement arrived, he approached me for releasing the machineries, which there were 2 piling rigs. So I told him that since it is pending, you submit a bank guarantee and take the piling rigs. So he had taken the piling rigs. Now, as a part of settlement of the award, I had paid the entire cost which accrued towards the machineries also, including the piling rigs. Now, since that had been paid off to the respondent number one, I encashed the bank guarantee. Now he is claiming the money on the bank guarantee.
But the arbitration,
That is
cancellation of contract, arbitration and settlement with the settlement of the dispute with the respondent number two, everything has been done behind the back of the petitioner, whereas the respondent number one is well aware that I am.
Let us admit
I am there.
it. Let us admit the matter, fix it for hearing, we'll give you the fixed date.
Lordship.
That would be better.
My lord.
Heard Mr.
Lord.
Dina Land counsel for the petitioner and Mr. And also heard Ms. D. Goswami for respondent number one. Who else are appearing?
Two, my lord, we have taken steps, but they have not entered appearance.
It's served, notice is served.
Sir,
Obviously, they may not be interested. Anyway,
one and two,
non appears for respondent number 2 and 3.
three is performer, my lord, three is
Okay,
performer.
dispatch service of notice. Admit list for hearing on, give the date.
But
After that,
after that.
after 10th,
After 10th of February.
After 10th or after 15th.
12th February. 12th. After 15 or 20?
17th, my lord, on
17,
Lord.
make it 17.
17th.
Ah.
Lord. Then 10th, my lord.
You decide,
I have, my lord, no difficulty, 12 February.
then 12th.
Yes,
Yes, make it 12th.
Lord. Oh, Lord.
It should be
Deeply
hearing there.
Your lordship, the matter may be passed over for the time being.
What is the matter?
Lordship, it's a payment of bills.
We see. Yes, when do you want?
Lordship, fix the matter to 2 o'clock.
Why?
Sir, Lordship Senior is in NCLT court at hearing matter.
Senior is
NCLT court at hearing matter.
NCRT.
NCLT court,
What is that?
National Company Tribunal Law.
It is submitted that the Mr.
Yeah, Dr. B.N. Gogoi.
Dr. B.N. Gogoi is busy in
NCLT court.
NCLT
T court.
court. In view of as appraised by the learned counsel for the spread by MS
P Talukdar.
P. Talukdar appearing on behalf of Mr. Dr. Gogoi. Let this matter be listed after 4 weeks.
Like,
My lord, the matter is, my lord, regarding claim of compensation for death of the son of petitioner's son, my lord.
Yes.
By electrocution, my lord. The son of the petitioner died on, my lord, 12 of February 2022, my lord, due to electrocution. While engaged in the work under
Yes.
the private respondent, my lord.
Under what policy?
Yes, my lord, a deep well was digging, my lord. While
Hmm.
digging a deep bore well, my lord, the son of the petitioner came into contact with a underground, my lord, cable live wire,
Hmm.
unsafe live wire, my lord. And my lord, immediately, my lord, he got injury. He was admitted in hospital. And,
Is there any report there? What is the report?
postmortem report is there, my lord. Immediately, my lord, the matter was intimated to police. Police, my lord, postmortem, done the postmortem. And the matter was informed to the Narangi, this sub-regional, my lord, electric, my lord, the Narangi electrical sub-region, the electrical authority also made the spot inquiry on the very same day. Police also made the inquiry on the very same day. But no compensation was paid immediately. Then, my lord, one representation was also filed before the authorities. They have not even considered my representation also, my lord.
Hmm. They filed the affidavit.
No evidence has been filed, my lord.
This is.
Respondent number 4, private respondent.
Private respondent filed, my lord. So his claim is very clear. His claim is that, my lord, since he is also not aware that under the ground there is a cable wire. My lord, many years back, my lord, the cable wire was, my lord, is installed by the
Underground cable.
underground cable.
Then?
So his part is that, sir, my lord, he is not aware. And ultimately, since the cable wire was in unsafe conditions, and ultimately this.
She was unaware of the underground cable.
Yes, my lord.
Who is for that? Who has to pay?
APDCL.
With the APDCL.
I am for the APDCL and respondent number 5 is implemented as a chief electrical inspector. So chief electrical inspector report is required for.
So you are not filing any affidavit.
File, but after the.
Who is for chief electrical?
Is not shown, my lord, for respondent number ZA is not shown.
Subsequently implemented, my lord, and notice was issued, my lord. But in the cause list, my lord, his name is not appearing.
So
Ultimately,
you can appear. Huh?
Government will.
Heard Mr. So-and-so learn counsel for the petitioner.
Copy to me, my lord, so that I can have a.
Yes, my lord.
Mr. MS M. Burman, learned state counsel, enters appearance on behalf of newly implemented
Respondent number 5, my lord.
respondent number 5, namely the chief electrical inspector, Government of Assam, who seeks for 3 weeks' time to file affidavit, file response list of Mr. So-and-so. Learned standing counsel.
KP Pathak.
So-and-so learned counsel appearing on Mr. KP Pathak, learned standing counsel APDCL, also pressed. That's also makes the same prayer, huh? Accordingly, let this matter be listed after 3 weeks so as to enable
Lordship.
the respondents to file their.
Lordship may fix a date, my lord.
Then counsel for the petitioner furnish a copy of the writ petition to
But
MS
wait,
M. Burman. Registry to reflect the name of GA. GA Assam,
Yes.
in the cause list.
Lordship may fix a date, my lord.
Yes. After 3 weeks, let them file first. We'll see.
MA Islam. All right.
Much obliged.
Obliged, my lord.
My senior SK Medhi is out of station. Kindly pass over the matter for.
What is the matter? Affidavit has been filed. What is the matter, madam?
We're in item number 28.
Okay. Heard MS so and so learned counsel for the petitioner.
Well, there has been some mistake perhaps, Milord. I guess item number 28 is our case, Milord.
Yes,
WPC number
6348.
6348. Yes, Milord. My friend is appearing. I don't know why, Milord.
Okay, let me
Perhaps,
confirm for my senior ones. Let me confirm for my senior.
I think it's not her item, Milord.
Your item is
It's written like 28, item 28 odd.
no name, nothing. Yes,
No. Yes, Milord.
yes.
But in this case, we are appearing for the petitioner. Insurance company, Milord, supposed to file
Yes.
their response, Milord.
Heard Mr. BK Sen, learned counsel for the petitioner. Petitioners.
My
Petitioners.
Petitioner, sole petitioner.
One, petitioner, Mr. Arson, learned counsel, enters appearance on behalf of respondent number 3, who seeks 3 weeks time to file affidavit. Prayer is allowed list after 3 weeks for file to file
Lord, you may
affidavit.
fix a date, Milord, after 3 weeks. Any
After
date,
4 weeks in that case, give
any
the
date,
date.
any date, Milord. 25. I am deeply obliged. In this case, well, it is to come after disposal of the writ appeal.
Is it?
Yes, so writ appeal has not been disposed of as yet. But pray that the matter may come up in the month of February.
After the disposal, after the disposal.
After the disposal.
We'll say that. It is, Mr. No, you'll record
File
this.
for the respondent for file.
We did us. No. Mr.
Both
V.
parties.
Sinha, learned counsel for the petitioner, and Mr. B.D. Das, learned senior counsel, assisted by,
Each other.
for respondent number,
4. 5, Milord.
for respondent number 5, and Mr.
SK for KS Udyal for SK Talukdar, Cooperation Department, 1, 2, 3, and 4.
Yes. Jointly submitted that this matter may be listed after the disposal of the WA
Yes.
Yes, sir.
number
Number, I don't have now, my lord.
So 120-25. 120-25.
147.
147.
147.
147. Which one is correct? 147.
There are three dates.
No, then in that case,
Done together.
120
25,
Oblique.
127,
120 of 2025
25 and 140.
and other connected writ appeals listed. Accordingly, let this matter be listed after the disposal of the writ appeals.
Obliged.
Yes?
The relief, my lord, as per my written instruction.
Okay, where is the word petitioner? claim is of amount of rupees? Okay, so it's been paid. Okay. Not appears for the petitioner on call. MSN Bardoli, London Standing Council, Revenue Department, and MS.M. Burman, London State Council, appearing for the respondents by placing the release order dated 26/03/2025, submits that the amount and an amount of rupees 4 lakhs as ex gratia payment has already been released and deposited in the account of the petitioner. Therefore, the grievance of the petitioner has duly been redressed. In view of the above, the petition has become in proxies. Accordingly, and accordingly, same stance closed. The copy of the release order dated 26/3/2025 is kept on record
Please.
for reference. Kept on record, marked as document X. Yes.
May be granted to file an affidavit, Lordship.
Yes, therefore, KACC. Mr. Hud, Mr. Yes, the Land Council for the petitioner. On the prayer, Mr. AMS. SK? Sorry, SK Empire, Land Standing Council, KAAC. Further 3 weeks' time is granted to file affidavit in opposition.
Not object.
Yes.
My lord, we'll take my affidavit for a moment. My lord, I am prepared for IIT. This case, my lord. That is record number 7, my lord. My lord, we'll take up my affidavit dated 12/12/2025, my lord.
Just wait. You support the petitioner?
I am in petition item 56.
If
you accept the state of Assam as a petitioner, my lord.
So?
My lord, what has happened is, my lord, we have filed an affidavit and we have stated before this court that the money, my lord will see the previous orders. So what had happened? Around 5 crore 20.
Just wait. Okay, then let me just.
So it.
Yes.
Yes, my lord.
He is supposed to take instruction, Mr. But Pujari.
They have filed an affidavit in connection to that. That affidavit dated 19/1/2026, my lord. Now, my lord, in that affidavit, they have stated, the Assam government have stated that in para number, my lord.
Where it is, page number?
My lord,
Additional
it is page
affidavit.
number,
207.
My lord, it's 217, my lord.
217 or 207?
My lord,
Additional
207 is my
affidavit
affidavit, my lord.
Additional affidavit filed by the.
IIT's affidavit is 207, my lord.
Then your, his affidavit is
217, my lord.
217.
My lord. Now, my lord, the issue here was.
Just wait. addition filed by and on behalf of respondent number 217.
My lord.
There's 217.
19-1, my lord.
This is not here. 217. 217. Okay, no, it's here. No. There's no affidavit.
Copy was given.
Yes, you just tell us.
My lord, what? So they in their affidavit have stated, my lord, that the money which they have received, the money was supposed to be received by IIT. My lord, my instruction is this, my lord. IIT has transferred the money. Point 1, my lord. There was another point. There was a calculation error on their part, on the part of the state government. Now, with regard to that, my lord, they picked the para number, my lord.
No, you have said that earlier it was shown as 24 lakhs 14,000.
My lord.
There's a and on recalculation, it comes around 1 crore 33 lakhs 41,000 something.
My lord.
So on that, what they are saying?
The paragraph, madam may refer to my affidavit.
It's not here. I mean, that's your 207.
My lord.
Page 207. That's you are relying. That's you are relying.
Yes, that's my, that's not there. Reply to my affidavit, they have filed an affidavit, my lord.
No, that is not here.
I'm just showing that what they have said on that question, my lord, of additional amount.
They said what here?
The part which is highlighted.
Records and found that due to an lack of official correspondence, the order that it did not come under the purview of the Office of District Commissioner at Mingaon, and therefore the correct award stated was calculated in the letter
Start from para number 4, my lord, and start from para number 4.
addressed to the Chief Secretary and consequently represent.
My lord, may I also peruse para number 4, my lord, for a moment, and
Yes.
my lord, if I may, as for the last order, was submitted that 5 crore 24 lakhs were received by IIT. And the money was supposed to be received by the state of Assam. My instruction is this, my lord, that money on 8th of January was given to state of Assam already. That 5 crore 25 lakhs, 24 lakhs is already.
5 crore 24 lakhs 76,000.
And there is also, my lord, another letter which Ministry of Education has written.
Just wait. I'm not able to get it. Now the issue is what? The problem is what now?
Well, the problem is twofold. First, the first problem was who was supposed to pay the money. The initial 5 crore 24 lakhs, that apparently ministry has transferred after
To the-
with central government.
So
Central government has transferred that money to IIT and IIT ultimately transferred that to
government.
state of Assam.
State of Assam.
The second part of the question was this, my lord, that because there was an error on the part of state of Assam apparently, that created an additional liability of 1 crore 17 lakhs and figure was there.
I mean, minus this 5 crore.
Yes, my lord, minus excluding this 5 crore.
Excluding 5 crores, so there is a additional liability of 1 crore 33 lakhs 41,482.
My lord,
It may not be a 1 crore.
that is their calculation.
More 1 crore because earlier it was 24 lakhs.
My lord, what my idea, my lord, what they have state government council may be able to supply better facts, but at the section 28 interest, my lord, that probably they have not calculated. If that interest would have been calculated, maybe the figure may increase from 24 lakhs, but whether it is 1 crore or whatever, that is exclusively under their.
No, what they are saying is that there was a on recalculation earlier it was 24 lakhs 14,000. Now it on recalculation it comes around 1 crore 33 lakhs odd amount for late Krishna Chandra Burua.
Yes, my lord.
So this is a liability and it is minus the amount which has already been deposited.
If my lord minus that liability, the amount, subtracted the amount deposited, then it becomes 1,71,223. That my lord will file in page number 216. In page number 216 of my
Problem is,
affidavit.
there is no 216.
My lord, my affidavit is there, my lord. My lord, page
This
number
one.
No, my lord would take up page number 216 for a moment. How much?
216, yes, this, yes,
Last page is 216, my lord.
yes.
It is a letter. It starts from 215, it goes to 216. Now, my lord, in para number, in
So
column number 17, my lord.
Yes,
It may come to column number.
payable amount, huh?
Yes, my lord.
One,
Payable amount. That becomes 1,71,223. Excluding the 24 lakhs, if 24 lakhs is added, that becomes 1,33 lakhs, my lord.
So 24, if it is excluded, then it comes around.
1,71.
So this is in addition to the amount which had already been paid by the ministry. So in that, what your submission will be in that case, if it is to be, the state has to.
My submission is, my lord, ministry's letter. Ministry has said, my lord, in this letter is written on 16th of December, my lord. That is not in the affidavit, my lord. It has just been given to me.
Saying what?
Say that they will not pay that. They will not pay any additional amount.
So who will pay about that?
That, my lord.
So you are also.
My lord, I am being IIT, my lord. IIT is an institute which was not there at the time of land acquisition. The ministry was there. And the land
So
acquisition was.
according to you are absolved from all this problem.
No,
You
my
have
lord,
you have no problem.
My lord, because IIT was not, institute is completely funded by.
Therefore, you are not.
I am absolved from this liability.
Yeah, that is what you are trying to say. So it's between the ministry and the state government. So ministry saying that you are not going to pay. So who is the government? Writ petitioner.
Before this part, this is a second part. Regarding first part, this particular writ petition number 92. The amount involved is 4 crores something. I am appearing for landowner respondent number 1, 2, 3. 4 crores something. And they have, the petitioners have clubbed other claimants also. And therefore, a calculation was given 5 crores, this 24 lakh 76,000. After a meeting, it has been decided, agreed, and ministry has paid this. Now, my humble submission, in this writ petition, only 4 crores something is involved. We have not been paid for long. So now my learned friend has submitted, he has submitted document also that IIT has also transferred money to the state government.
5 crore.
Yes, 5 crore. 5 crore is not involved in my case. It's only 4 crore. So my humble submission.
5 crore is the different.
Yes, to tell other cases involved. In this case.
Your case is?
This 92, first case, item number 55.
Filed by the state.
Yes, the petition is filed by the state because we filed money execution case. So they have come before the court.
So you are not concerned about 5 crore?
No, up to 4 crore.
What about, you are claiming under the 5 crore or?
Yes, included in the 5. Included. I have submission.
What is your, how much you are entitled?
4 crore something, 4 crore 63 lakhs. It is in the petition itself. 4 crore 63 lakhs something.
Who is for the state, madam? Yes. What is your case?
This matter, in WPC 92/2023, Lordship, an affidavit was filed on 19th of January, which is not tagged with your Lordship's record.
Just tell us.
Yes.
Amount has, they say that IIT has also said that it has been deposited to the state around 5 crore and odd rupees, right? And the landowners, they are saying that they are interested around nearly 4 crores. Then I think, I mean,
that
if
amount will be deposited.
IFSC, all this 1 crore, the recalculate also may be included.
For that purpose, the writ petition may continue. But so far as our amount is concerned, The state government may be directed to deposit our entitled amount to the court.
My lord, I have a
Your
sub-
lordship, in this matter, the affidavit was filed on 19th of January, which is
Yes,
not
where is this?
not
It's not-
tagged with
not-
the record, your lordship. Also, your lordship, the engaged
Copy
counsel
was given to lordship.
is on legs.
I am representing
They don't need it.
4 and 5.
Who is respondent 4 and 5?
I can find an affidavit on this.
Again, what about you?
1, 3, and the.
So total is
Our this 446.
63.
The execution is standing with the trial court. They have given the creation of the central government on a IIT has not deposited money. And that's what, and because the competency is pending, that possibility is also. But the calculation interest amount is of September 09. And the interest is increasing day by day. If they are not paid, again, the interest amount will be the going from the public. So my lord, only the direction issues, they have deposited our amount, which is related in WPC number 9. That may be deposited in executive.
We'll take it up.
May kindly take it up at 2 o'clock, your lordship. 2 o'clock. The engaged counsel is on legs at court number 1.
I
your
also have to
lordship.
file an affidavit, my lord, in this.
Huh?
On the last affidavit which they have filed,
Which is-
IIT, my instruction is this, IIT will to file an affidavit.
You should also file.
Yes, my lord, IB will also be granted an opportunity to file an affidavit on that point.
You
my
have
lord.
received that.
Yes, my lord,
We have
that,
served the copies, your lordship, but it is not tagged.
Then
with-
we'll fix it on 28.
Any day, my lord,
27.
Lordship, he will find defeat regarding the second part, this anomalies. But the first part is concerned.
No,
Our
no.
priority
For that, I would like to be very clear about. No issue. We will direct, because they say this, because we'd like to hear them, no? The petitioner, the state. If it is deposited, if you are entitled, we'll definitely will direct that.
Yes.
I mean, now I think, I don't know. This, your stand and they will be clear in your additional
Yes, your
affidavit.
lordship, it was filed 19th,
So-
your lordship, day before
It
yesterday.
reported ministerial speak to the IIT.
Ah,
Now today my friend is for IIT has submitted.
it has already been deposited to state. We'll take it up at 2 in that
Yes,
case.
your lordship. Yes, your lordship.
Then again, they will have to, if they file the affidavit,
that one, my lord, I'm-
we'll see. You, it is submitted by MSN Board Learned State Council. Learned Council petition in WPC 92, 2023. No. We'll take it up at 2 o'clock. I mean, you try to call for that affidavit. Call for that affidavit. Huh?
I'm deeply appreciative.
Not appeal or provisions. Provision to court.
Wait, please, Lordship. Lordship, the Ministry of Petroleum and Mineral Gas.
Bill provisions.
Yes.
The respondent number 1, Lordship, has acquired a plot of land from the petitioner for laying gas pipeline, which is laid on from Guwahati to Barauni gas line project, BGPL project, Lordship. And after the acquired, they have issued a notice, Lordship. That is annexure to page 44, Lordship. And in the notice, middle portion of that compensation for the land, crops and other properties will be made according to Schedule 10 and 11 of the Petroleum and Mineral Acquisition of Right of User in Land Act 1962. And as per the Act of 1962, compensation will be 10% of the market value determined by the administration, local administration, Lordship. And thereafter, the petitioner filed a representation before the competent authority to assess the land compensation as per the Fair Act 2013. And that has been rejected, and the rejection order is Annexure 3, page 45, Lordship. An operative portion is page 46. Second paragraph. However, it is noted that the right of use acquisition has taken place as per provisions of the Petroleum Mineral Pipelines Acquisition of Right of Use of Land Act 1962. Therefore, due compensation would be received under section 10 and 11 of Petroleum and Mineral Pipelines Acquisition of Right of Use of Land Act 1962. As such, land compensation cannot be given according to right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. Lordship.
Yes.
Thereafter, the petitioner approached the learned district judge. The petition is page 51, Annexure 6, Lordship. After filing this petition, the respondent number 1, Gail India Limited, has submitted written statement, that is Annexure 7, page 60, Lordship.
Which order you are challenging?
I have challenged the order, that is Annexure 12, page 78, Lordship, that passed by the learned additional district judge Borpeta, Lordship.
Yes. Come to that.
Lordship, come to the page 83 of the impugned judgment. 83, Lordship. There is 4 issues were framed, Lordship.
Yes, then.
And findings of the learned trial court, one is that the petition is premature, that the competent authority has not decided the compensation. That is not correct, Lordship. In the written statement, the respondent number 1 clearly stated that the compensation of the petitioner was already determined, and petitioner was identified as one of the beneficiary of that patta, and his compensation was pending since the petitioner has not submitted the necessary documents to the respondent number 1, Lordship. That page 67, that in para 5, that is clearly stated. Compensation has been determined and declared by the competent authority as per the Petroleum and Mineral Pipeline Act 1960. The petitioner is verified as one of the 3 beneficiaries in the affected area under the Act as per the Joint Field Verification Report Panchanama carried out by the representatives of the Circle Office, Gaubura, Latmandal, representative of the competent authority, Gale, representative landowners. However, he has not signed the Panchanama and submitted the report documents, declaration form for receiving compensation through electronic mode, copy of photo passbook, photo, proof of identity and proof of address. Only his compensation has been pending in the notified that compensation to the other beneficiaries have been already disbursed to them by the competent authority.
Yes.
But and an important parties lordship is 106 lordship of this writ petition lordship. And 65, paragraph number 65 of the impugn order lordship. It is therefore seen that the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, removable order 2015 had been issued by the central government without jurisdiction. Hence, the same cannot be enforced. As such, it is held that the petitioner is entitled to calculation of compensation under the RFCTLARR Act 2013, and thus the issue number 3 is answered in the negative and against the petitioner. Lordship, in the 2013, the Fair Act has been came lordship, and in the Fair Act, lordship, some rupees.
You read that?
I'm sorry, I was late. My lord, the issue involved in this case is whether the district judge who dealt with the matter could have dealt with in the manner as has been done. My lord, it is on a very narrow compass, my lord. If your lordship would kindly have the 2013 Act. Before we go to anything else, my lord.
Yes, I have.
Yes. It 15 year order. How do I do? 10 10 yes. More kitabpan anan more kitabpan ki hai?
Yes, which
Yes.
section?
My lord will kindly have the act, my lord.
Yes, I have.
Come to section 105. 105. Subject to subsection 3, the provisions of this act shall not apply to enactments relating to land acquisition specified in the 4th schedule.
Yes.
Now, my lord will kindly come to the 4th schedule. It is at page number, towards page 58 of my book. Petroleum. Na?
Yes.
If your lordship will kindly come to entry 8, my lord, of this
Petrol and
schedule,
mineral. Huh.
Petroleum Mineral Pipeline Act.
Yes.
So, my lord, by virtue of section 105, the provisions of 2013 Act will not apply to any acquisition undertaken under the following statute. Amongst others, we are concerned with entry number 8. Now, my lord will kindly come to section 106.
Yes.
Yes,
power to amend.
Yes.
Said it.
Central government may by notification amend or alter the schedules to this act without in any way reducing compensation or diluting the provisions of this act relating to compensation or revenue. A copy of the every notification proposed to be issued under section 1 shall be laid before each. So, my lord, one such procedure is 106. My lord will kindly come to section 113 now. 3000. Yes. Section 113.
Yes.
If any difficulty arises in giving effect to the provisions of this act, central government may by order make such a provision or give such direction not inconsistent with the provisions of this act as may appear to it to be necessary or expedient for removal of the difficulty, provided that no such power shall be exercised after expiry of a period of 2 years from the commencement of this act. So, my lord, the bar which was imposed by section 105, that can be removed by the central government by invoking section 113. Am I clear, my lord? Now, my lord, under section 113, this order has been issued. Copy of the item. It order to go. If your lordship would kindly come to that order, which is at, in my book, it is page 80. Right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, removal of difficulties order 215. Whether lordships got it, my lord?
Yes, yes.
Yes. Now kindly come to this order, my lord. This order may be called right to fair compensation and transparency in land acquisition, rehabilitation and resettlement and removal of difficulties order 2015. It shall come into force with effect from the first day of September 2015. The provisions of right to fair compensation and transparency in land acquisition, rehabilitation, resettlement act relating to determination of compensation in accordance with the first schedule, rehabilitation and resettlement in accordance with the fourth schedule, second schedule, and the infrastructure amenities in accordance with the third schedule shall apply to all cases of land acquisition under enactment specified in fourth schedule to the act. So what was prohibited by section 105, central government was empowered to issue an order under 113, and under 113 this order has been issued. So now therefore, my lord, the petitioner is entitled to compensation under 2013 Act. This is the legal position. Now kindly see, my lord, the learned session district judge who dealt with the issue, please come to the impugn order at page 79. It is an associate order, my lord. No application of mine.
You have read this page 481.
Yes, my lord.
It said
Yes.
come into force with effect so and so.
Yes, yes.
This order may be
So by this order, my lord,
provision
the
right to
difficulties have been removed.
relating to the determination of compensation.
In other words, whatever bar was there, that has been removed.
The first schedule, second schedule.
Shall apply to all cases of land acquisition under enactment specified in fourth schedule of the said act. Nagpur Development Authority Administration.
His number will be announced.
Yes.
Yes. My lord will kindly come to the impugn order, my lord, page 104.
Yes.
Page 104, para 62. Learned counsel for the petitioner has contended that petitioner is entitled to recover compensation as calculated as per Act of 2013. It is pertinent to note that the only grievance of the petitioner is that, according to the petitioner, the compensation ought to have been determined under Act of 2013, as central government had wide right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement, removal of difficulties order, made the provision of Rector Act of 2013 applicable for determination of compensation under section so and so. So far, so good. However, the Honorable Bombay High Court had in the case of so and so held that central government had issued the right to so and so order without jurisdiction. Hence, this same would have no effect. The relevant provisions of the above judgment. So, my lord, the session judge is relying upon the Bombay High Court order. In our view, failure on the part of the central government in following the said mandatory procedure could not be ratified by issuance of removal of difficulty order by invoking section 113 of the Act of 2013. Said removal of difficulty order issued by central government is without jurisdiction, as the same is issued not for making such provision or give such direction not inconsistent with provisions of the Act, but is to cover up the default in not issuing notification within a time prescribed under section 1053. The time prescribed under section 1053 to issue such compensation in the mode and manner prescribed under section 105 is sacrosanct. In these circumstances, central government could not have exercised power vested under section 113 of the Act. Central government under the guise of removal of so my lord, Bombay High Court has taken the view that this order is without jurisdiction. Anyway, my lord, there are Supreme Court judgment which says otherwise. Now, in view of this, my lord, our case was dismissed. Now, after 2 o'clock, my lord, I'll place the order of the Supreme Court, where Supreme Court has said there's nothing like it.
We will continue.
Request, let the other side complete the arguments. Can I give my reply tomorrow? I have some personal difficulty in the second.
Tomorrow.
Some official duty.
Tomorrow it is possible.
Then next week, Lordship, Tuesday.
It's better. In that case, tomorrow it may not be possible.
In that case, my lord, I also will give my submission Tuesday, my lord. Or Lordship want me to complete it, as your Lordship wishes.
No, it will hear you
Yes.
on that day only.
Both.
Both.
Yes.
Huh.
Well, I have placed the facts. Now I'll just make 2 more submissions. That's
That's
it's a clear cut, open and short case. There's nothing like it.
We'll see how open and clear.
According to us, my lord. According to us.
Okay. Well, just then in that case, we'll just keep it part hard.
Yes.
Because you have spent considerable amount of time. Heard Mr. Ken Shoddy, Learned Senior Counsel, assisted by Mr. Ayushin, Learned Counsel by Petition, and also DSEC, Learned Senior Counsel for Respondents, assisted by Swencha. You are not as a senior counsel assisted by Swencha for respondent number Swencha. List the matter as agreed to by parties. List this matter on 28.
27
is Tuesday.
Is it Tuesday?
27. 27/01/2026 as part hard.
My lord, can I take little liberty? Item number 52. With your lordship, I think today is a long list. There's some urgency at around 3:34 million. We'll take a chance.
Let us see.
Yes. I'm sorry.
Yes. Yes, sir.
Well, this is a writ petition, my lord. The state has to file this writ petition on constrained circumstances. Now, my lord, for the establishment
Things
of.
has boiled down. You just tell us about your additional affidavit.
Yes, that additional affidavit has come on record. If lordship may be pleased to come to my lord, is 223, running page 223.
Yes.
That is annexure 1. Roman 1.
Yes.
This was the judgment and order passed by the reference court. Now,
my lord, in pursuance of this judgment and order, lordship will find, my lord, the operative portion at page 236. I'm troubling my lord with all these pages, my lord. 236, for a moment, my lord. 233. 236. 233. Order. My lord, I stand
Order.
correct. I stand corrected, my lord.
Yes, internal page 14.
My lord,
Yes.
I'm so obliged. Now, the petitioners are entitled to compensation of the land assessed at the rate of rupees 1,25,000 per bigha and also entitled to 12% interest in addition to the market value as per provisions of section 23(1)(a) of the Act. Now, thereafter, my lord, we had made a communication. Lordship will kindly turn to the next page, my lord.
Yes.
Now, the interest component was not being paid by the authorities, my lord, on behalf of whom the land was acquired by the collector, that is the district commissioner, whom I am representing. Now, this interest component, my lord, comes to rupees 24,14,000. At the very first paragraph, lordship has seen it, my lord. So we have duly communicated. And this was communicated, my lord, by the IIT to the district commissioner. This is a communication from the IIT to the district commissioner. They have admitted it. Now, what has happened, the next was thereafter, my lord. The petitioners, that means, my lord, the landowners, being aggrieved by the quantum of interest that was awarded to them, they filed this review application. They filed this review application. And in this review application, my lord, this order has been passed. Whereby, lordship will see, my lord, at page, my lord, internal page number 5, my lord, down below, lordship will find, my lord, of that order. Lordship has seen it, my lord. Internal page number 5, the last paragraph. In view of the above, the review petition is allowed and it is held that the petitioners who are the claimants of reference case number 83 of 2016 and 84 of 2016 are entitled for interest at the rate of 9% per annum on the excess amount of compensation awarded by this court for a period of 1 year from the date on which the landed collector had taken possession of the acquired land, and 1 year thereafter at the rate of 15% per annum on the excess amount as per section 28 of the Act. Now, this was the order passed in review application by the court, my lord, by the reference court below. And this has attained finality. Nobody has objected thereto. Now, my lord, component, which was originally 24 lakhs, which lordship has just now seen, had sought up to the amount of rupees, my lord, 1,33,41,483.
Yes.
That lordship will find at the very next page. Accordingly, we had, my lord, made a communication on 12th of December 2025 to the IIT. Now, my lord, the IIT is disputing this.
This 24 lakhs, 14,000 is not in respect of the 1% or is it entire the interest amount?
Entire interest amount.
So it has
sought up
to 1,33 lakhs.
1,33. Lordship will kindly appreciate one aspect of the matter. I am the collector. I am
No,
only
no,
the.
it's okay, it's okay. Before that, actually, let us understand first. Now, they have deposited the amount to you.
The Ministry of Human Resources, Union of India had
Deposited to IIT, IIT has deposited to you.
No.
That is their stand.
They still let them put on affidavit. Let them
What is
put on
this?
affidavit.
My lord will allow me on that case. My learned senior is saying this.
Just wait.
And
Say,
yes,
keeping aside this deposit, the total amount is 5 crore and odd.
5 crore, including all the refinance cases which are pending. We want to settle it for once and all.
No, I don't know. The landowners, they're saying that their claim is around 4 crores.
4 crores, that has now, because the interest component keeps on adding, my lord. It is a cumulative effect. So interest is going up day by day.
Obviously, that's what I'm saying.
Yes.
Now, if the total amount deposited is 5 crore
5 crores.
and the total claim by this claim of the landowners is 4 crores and odd, there remains around 1 crore.
Yes, 1 crore, but 1
You
crore.
4 crore add your this 1 crore 33 lakhs. I think.
Yes, they will have to pay it because what?
No, total amount is deposited is paid is, although not paid to the landowners by the requiring authority or the authority who has to pay, they have deposited 5 crores and odd
Yes,
amount.
Yes, but that within that 5 crores, the differential amount 133 minus 24 lakhs and an odd amount, that is not paid. That is not calculated within, my lord, that 5 crore. Because of the simple reason that the order passed in review petition laid by one of the landowners were never communicated to us. When we came to know about it, my lord, we immediately requested the IIT.
What IIT says now?
IIT says that we are not going to pay.
My lord, if I name it,
That is the difficulty, my lord.
This is very simple issue. Why you cannot pay? There is a direction of the court.
My lord, if I may, my lord, because I think the limited facts which have been presented, that may not be EA. My lord, what has happened, both in the cases of review and in the reference case, collector was a party. I am saying it with all responsibility, my lord, because I was there on that case, my lord. And the review order was, my lord, I do not want to trouble this honorable court, but the review order, which my learned senior has shown, that review order also, the party number 1 was collected. The first page of the review order is not there. My lord will allow me to put everything on.
No, it is hereby made clear the OP number 1. The collector shall collect the amount from OP number 2, IIT.
That should just address this point. What they were not aware. The ground which they are now conversing that they were not aware, that is not true. I will come on the liability part, my lord. Now, my lord, for a moment, we'll turn to page number, my lord, 142 for a moment, my lord. Because everything starts from there.
No, we are not going into all these other disputed things. Only will go. What do you say about this? You just tell us. Page 24, the order of review order by the court in the review, where it says that page 240, internal page 66.
My lord is looking into page number
240. The way the interest was enhanced. Yes, this is 240, here 240.
Let me address this point, my lord. But my lord will allow me to complete my point, my lord. This order is put to challenge, my lord.
Then?
This order is now before, today this case is listed before the court number 14. I will argue the matter there also, my lord. There we are, IIT is challenging this award also, where there the state government is party. We have given them a copy. It's not that we are doing this order of.
Is there any stay on this?
My lord, the matter will be today heard, my lord.
I'm asking when any stay or the stays.
Still now nothing. But let me just complete my point, my lord. This 5 crore odd money came because of a calculation done by the state government themselves. That is
It's okay. That was wrongly calculated, whatever. There was a mistake.
My lord, the mistake.
Now, according to them, they said recalculated, it comes to this much. Near about 1 crore, more than 1 crore.
They realize this. My lord will turn to page number 2.
Now, we have to resolve it. It's not creating a problem now.
Liability. That is my humble prayer and
How? Why not?
Yes, my lord. How? Because
You get it set aside. Then matter ends there.
That order is under challenge, my lord.
That's what I'm saying. Then if it is allowed, if it is in your favor, if it is in your favor, matter ends there. There is no question of 1 crore excess amount.
The idea of honorable court before was, my lord, that my lord the court wanted a settlement of all cases, and accordingly a meeting was called. In the meeting, state government given that detail of this case also, but an error on their part, they did not give that.
It's okay, error is there, error is there.
Sir, because the sanctioning authority in this case is not IIT Guwahati, my lord, it's the central government.
You take it up.
No, my lord, that is,
How can you just hands your up?
my lord, IIT cannot, my lord, with all humbleness, my lord, it is not in the domain of IIT, my lord, because IIT is
It
not a party
involve
of the state.
IIT, public institution. You may have autonomous the body, but the state government, central government, as if you are not, you are acting like a private party.
Not at all, my lord, if an impression has gone, my lord, I'm
Is we want to resolve it, you have acquired the land, 2
Land
crores,
was
3
acquired-
crore additional you have to pay. That is where there is a direction, or else get it settled by the court in the appropriate thing.
They have filed an affidavit.
Because I just don't want to create a problem. Rather, we should try to resolve it.
That was the idea.
See, as I said, you are a petitioner in the state government, central government is there, you are IIT, and the landowners are suffering.
My lord, the central government with all,
Litigation after litigations.
my lord, it is the central government who has denied
Don't
the
act
request.
like
my lord.
a private body.
My lord, it is
private
not IIT
party.
who has denied the request, my lord, it is the
Why?
central.
Why?
Because that is what the letter which I
That
wanted
you
to
have
do,
to
my lord.
work it out, right? You just
My lord, it is
cannot.
between central government
pass
and
the
state
buck.
government, my lord, that was the issue, because central government and.
Can you not be a part of it? You are also a public body. Although
When the
you may be
meeting-
autonomous. I mean, don't act like a private body.
We are not, my lord, but the limitation in this case was this, when the.
What limitation? Nothing. It can be resolved within a minute if you wish.
My lord, then let them communicate these things to the central government, my lord, and central government is there, my lord, my lord, to resolve it.
Why? You have to take a call to the central government.
From our part, we will do it, my lord, but let them also communicate to the central government.
You are happy that central government, I cannot pay, and you said the central government don't want to pay, we cannot do anything. You cannot, it cannot be. See, land composition, it's beneficial legislation, right? You have taken the land of the people.
On that case, my lord, let another meeting be called, let me propose this, my lord, let the another meeting be called and let the central government and we will all try to probably settle it out, my lord.
My lord, I do not know why this submission is forthcoming from their side. For a moment, Lordship may kindly peruse order dated 15/12. First in the writ petition. For a moment, my lord. For a moment. It is the admitted position on record, my lord. The second paragraph. For a moment, my lord.
Sir, all of you, I'm requesting 1512.
Yes, 15/12. 15/12/25.
Yes, considering some is, you said,
My lord, the
land
second
submit
paragraph.
in view of the, the land compiling and has brought on record inadvertent mistake in calculation composition amount disclosed. Tanuja Barma.
Paragraph. My lord, the second paragraph.
Which was earlier shown as rupees 24 and so and so, and now has now been calculated to rupees 1,33,000. Yes, this is on the basis of the last in the review order.
No, my lord, Lordship will kindly peruse the second paragraph. Mr. R.K.D. Chaudhary, learned Deputy Solicitor General of India, submits that the agreed amount of rupees 5,24,76,407 has already been released to the IIT.
That money has been paid, my lord. That is my instruction. I have your document to show that also, my lord. That money has been paid back to the
Paid to the whom?
To DC Kamrup, my lord.
Well,
collector.
8th of, my lord, I will tell the details on that case, my lord.
I am taken by surprise.
Mr. Day,
I am
My lord,
taken by
on
surprise.
give it to him. Give it to him. I have seen it. Give
I
it
am
to him.
taken by surprise.
See, what can be done in a second? Why I mean,
Yesterday.
This 8/1, sir. It is not yesterday. It is 8/1 the money has been paid.
This is
There is an internal communication to me, but the money credit date is 8/1, sir.
we're fixing it on 29.
yesterday.
What 29? You resolve it. Resolve it immediately. Yes.
Regarding this payment of 5 crore. So all this submission has been made in the second part.
Yes, keeping this, keeping the dispute regarding the enhanced interest or, I mean, specifically, particularly the 1 crore 33 lakhs, will decide.
Yes.
You take instruction on that.
because this 524C is there.
Yes, yes.
On next date,
Absolutely.
we'll direct you to release the
Absolutely,
landowners.
Absolutely. It is.
Whatever
public
whatever is submitted,
Yes, yes, we are ready.
whatever disputed amount or that will can be settled.
Yes.
I mean, after that. Maybe. They have to, not only to you. Doesn't matter. Doesn't matter. They don't have to be party because if you are aggrieved, they are also equally aggrieved. So we'll see.
On 15th of December 2025, the highest legal authority officer of the central government makes a submission before his honorable court that this 5 crore 24 lakh.
It's okay, it's okay. We'll not go back.
No,
We'll see. We'll see. I've seen it.
Matter-
I have seen this. This is
Yes.
my order. This
My
court's
conduct
order. We'll see.
Yes.
Now, they said it was deposited to the IIT for onward payment. They have deposited on,
Yesterday, it is an email.
whatever.
For the
Whatever.
first time I
Ah,
am having this document. I
You
will
take
take
a
instruction. I will
you
take
take a instruction
Yes.
and we'll say,
Yes.
if it is deposited, the collector so-and-so is at liberty to disburse.
Disburse forthwith. It is
Disburse
no point
forthwith,
keeping
right?
This money, yes,
Yes.
yes, forthwith.
Heard,
No point.
heard
keeping their money.
Mr. Arbor Pujari,
Forthwith.
learned counsel for the petitioners in WPC 92 of 2023, and Mr. K.M. Hassan, learned counsel for petitioner in WPC 3661 of 2018. Next para, it is and Mr. A.B. Day, learned counsel for the petitioner, learned counsel for the learned standing as IIT, respond number 2. Respond number 7.
6 is state government, central government, and 7 is bus.
Respond number 7. By placing the copy of the
Internal communication, my lord.
what is this?
It's basically internal communication between IIT
Copy
department.
of the
It's a email.
total communication
Email communication.
from the accounts officer, finance and accounts section, IIT Guwahati, submits that an amount of rupees 5 crore 24 lakhs 76,407 payment by the paid by the central government or Ministry of what? Ministry of Education, Government of India has been deposited to the
Has been transferred to
deposited and transferred to the collector oblique district commissioner
Kamrup, my lord.
Kamrup Amingao on when? 08/01/2026 for onward payment to the landowners. Landowners.
Landowner.
No,
Landowners involved in the present litigation. That is why, my lord, they have mentioned.
no,
the
we'll say
litigation.
the landowners.
Yes.
We'll say landowners.
In the-
Only this amount is for landowners only.
Landowners and more particularly to the present litigation.
We'll say, we'll not say no, landowners. We'll say landowners. Landowners, right? Mr. Arbor Pujari submits that he has been taken
Taken by surprise.
However, he fairly submits that if the amount is deposited already to the collector, there would not be any bar
Absolutely.
to disperse
Yes.
to the affected
Yes.
landowners,
Yes. Yes.
for which he would like to obtain instruction.
yes.
This stuff. Considering above, let this matter be listed on when?
After 1 week.
Make
my
it 1 week, 2 weeks, whatever.
lord. 1 week. 1 week. 1 week will do, my lord.
Make it 2 weeks. Because I'll be passing, will allow you to disperse if it is deposited.
Right, absolutely. Then can it be on, my lord, 5th of February, my lord, or 6th
5th of February. Huh?
6th of February.
6th of February.
My lord, I'm so obliged.
In the meantime, Mr. Since Mr. Bhattacharya, understanding is counsel for the petitioner, has also filed an additional affidavit as regards the additional affidavit, which is taken on record today, Mr. De, Land Standing Council IIT, may file a reply to the said additional affidavit. Yes.
Central government, which I wanted to rely upon, my lord. For a
No, you file it.
My lord, that
will
where
be-
they have communicated to the state government, my lord, the amount will not.
He has already said, you file your reply to the additional affidavit. He has pushed the burden on you, all right? And may file affidavit. You bring all those things,
I will bring on this.
including, and the MS so-and-so may also file reply to the said additional affidavit filed by the state oblique petitioner, Next para. Considering that the landowners is suffering due to non-payment of the compensation. Since when?
Since 2005.
In view of the
2005.
since many years, in view of the litigations, it is directed that the collector shall disburse the amount to the landowners if the compensation amount of rupees so and so 5 lakhs, 5 crore 20% is deposited. The copy of the communication placed by the Mr. De, Land Standing IIT, is placed on record and marked as okay.
No difficulty, my lord, same meaning. Lordship has directed it to
Directed
take the
to
pattada.
disperse in accordance with law.
Yes.
That includes whether to deposit where, whatever. Right?
It is not
No,
our
no,
money. It is their money.
you just sincere.
Yes, it is their money, the
Mr.
private
There.
applicant's money.
Now,
Why should we keep
you
it?
just advise the IIT. As I said, don't take
Yes.
it like, it's like I'm not, don't take it like I'm using the hearse. What? Because though you have the autonomous body, but you're a public institute, so negotiate and work it out. And the state government, central government, nobody, no private parties involved.
Request, my lord, if
It's
there
a fight between the authorities.
is- My lord, if I.
Normally, the fight is between the authorities and the private
The
party.
settlement was, my lord, done because.
No,
of the
it's
court-
a fight within the authorities.
Settlement had arrived because of court order.
And that too, Mr. Bhattacharya,
My lord.
double engine.
Yes, man.
Your double engine is not working.
But it has worked, my lord. It is only because of them. I will-
Either of the engine is failed.
Prima facie,
There is
it
a
has
communication
worked.
gap, it appears, my lord.
Prima facie, it has worked. I'm so obliged.
Obliged.
58. Yes, Talukdar.
Matter, my lord, the judgment. I will take your lordship to
Two paragraphs. Yes.
lordship may come to paragraph 12.
12.
12.
Yes.
There is no allegation against the writ petitioner to the effect that he had a direct role played.
Para 12.
Para 12.
In the present case.
Such in the present case, I have read it from the next page. Immediate. There is no allegation, as your lordship got. there is no allegation against the writ petitioner to the effect that he had a direct role to play in diversion of the rice bags. There is also nothing on record to show even the indirect involvement of the petitioner in the diversion case. That is the observation. In that case, my lord, there was no allegation against them.
No, no, direct allegation is not there, but material doesn't indicate any even indirect involvement. That is what you are
In
trying.
that case, the earlier case.
But do you admit that you made the same submission which you have made here?
In the earlier case, it was filed by an individual. There is no allegation against it. But in the present case, we have found there are allegations against the involvement of the society. And I'll place that, my lord. Then your lordship may come to paragraph 60. Paragraph 60. As noted, there is not even an iota of evidence on record to suggest that the petitioner had acted in violation of the terms and conditions of the contract. The writ petitioner is also not named in the FIR. This is not the case. In the present case,
The petitioner is named in
named
FIR.
the named accused in the FIR.
Yeah,
I'll take your lordship.
you are trying to distinguish.
My
This is distinguishable.
My
That is what you are saying.
I'll take your lordship to our affidavit, my lord.
Huh?
Our affidavit, that 2 points. Lordship may come to page 86. 86. This was the final report by us, our department. Second paragraph, member. On getting information from different sources that a huge quantity of PMGY rice has been diverted by the secretary and other office bearers of Messrs. So-and-so in league with transporter Messrs. So-and-so, the petitioner. There is a direct mileage allegation against them. And one part from the statement of the secretary of GPSS Society, mother, it appears that the one Mani Sahu, who works on behalf of the petitioner, my lord, he was involved.
Yes, page 88.
88.
Okay.
Then, my lord, will come to FIR. FIR is at page 91. Number 4 is the society.
Larua.
Basing on this fact, my lord, I'll reiterate my submission that the contract was a composite contract, my lord, tier 1 and 2. So he knew that he had to carry out both this tier 1 and tier 2.
Page numbers, what you have relied is page 76.
That is my submission.
Page 76.
No, 76 is the order, final order, speaking order.
Okay, 84 is there. Inquiry. Page 84. Oh, sorry.
84 was the preliminary inquiry, my lord.
Okay, 86 you are relying. Right.
84, it is also there in 84 and 86.
Then page 88.
Then page 80.
Then FIR is?
FIR is at 91.
91. And this judgment you are relying?
Judgment they relied, my lord.
No, relying is para 12 and 16. To show.
Yes.
To say that this can be distinguished. Okay, that's all. Heard Mr. K.K. Mohanta, learned senior counsel for the learned senior counsel assisted by Ms. M.S. N. Begum, learned counsel for the petitioner. And also heard Mr. B.J. Talukdar, learned senior counsel assisted by Mr. P.K. Medi, learned counsel for the respondents. Hearing concluded, judgment reserved.
In this case, Lordship, we have been directed to file our affidavit, Lordship. I am praying for some more time, Lordship.
Heard Mr. M.S.A. learned counsel for the petitioner. On the prayer of Mr. H. Sharma, learned additional sitting of an advocate. Further 3 weeks' time is granted to file affidavit.
There is an interim order.
Interim order passed, the shall continue. Are you sure there is an interim order?
Yes, my lord. Your Lordship may look into the
It's
order.
okay, it's okay.
Last time, the PWD has taken time to file the counter. So, my lord, as per my information, my lord, the instruction has been received by them. So they want to file the affidavit in opposition. They take 6 weeks, 1 week time.
Well,
By this,
weeks time.
no, as per the Nayak, I have talked with the Nayak, his senior. He said that within 1 week they will file the affidavit, and within 1 week, my lord,
Sir,
we
we are
can
not
reply.
concerned. She is equally capable to,
No, well, I do, my lord.
since she is appearing,
Yes, my lord, but.
so we'll
but-
go by her.
Yes, my lord, that may be, my lord. Matter may be fixed on 6th of February, my lord, for final disposal, my lord.
What is the matter?
My lord, it is a land acquisition matter, my lord. The money has not been paid. but
Why?
Work has been concluded in 2023.
Why you have not been paid?
My lord, is there direct agreement between the, my lord, there is a process of the direct land agreement as per the Assam Mala project, my lord. So total land value, total 5 crores, my lord, 87 lakhs, it has been already agreed between the parties. And that money
Okay,
has not been
heard
paid.
Mr.
P. Mahanta.
P. Mahanta, learned counsel for the petitioners. Petitioners?
Yes, my lord.
And
One petition.
this is third time you are seeking time, third or fourth time. And Mr. H. Sharma, learned state council, huh? And Bordoloi and so and so. MS M. Learned standing council PWD. Correspondence is granted further 3 weeks time to 2 weeks time to
Well, on the 6th February, my
2
lord,
weeks times to file affidavit in opposition.
matter fixed on 6th of February, my lord. There is 16th.
This is 2025 matter.
No, my lord, this is my lord, petition, work is completed.
After
No, my
10.
lord, one thing, my lord.
Sir,
Work-
after 10.
No, my.
If
this
you
is-
want a fixed date after 10.
Well, then, well, Lord, see, well, then on, this is 11th of this, no, well, this is on 12th February. Mass of life,
Yeah, please, Lordship. Lordship, can you pass over the matter for the timing, Lordship?
What is the matter?
Lordship, I am totally unknown, Lordship.
2 weeks time is granted to J. J and another.
Have an instruction, my lord, that sale permission could not be granted due to pendency of one title suit, my lord. This is the simple instruction, one line instruction I have received just now, my lord.
Yes, what is his claim?
Details are yet to be come.
My claim is, my lord, I'm the absolute owner of the land,
No,
my lord.
title deed is pending, therefore how can you be granted?
No, my lord, that land, my lord, has no nexus with my my lord, tag number of my land, my lord.
What is your prayer here?
Prayer here, my lord, for setting aside, the
Rejection,
taxes.
what is the rejection? 27.6. You said that because of the pendency of title suit, you have rejected his prayer. What is this annexure 10?
Annexure, page 40, my lord, kindly see, page 40. Annexure
40.
10, this is the rejection order, my lord, that I have applied for sale of my land, my lord, that has been, my lord, cancelled.
Not cancel, reject. Where is
Rejected, my lord. The
Where it says
application-
application tracking reference subjects, where it says?
My lord,
Where it says that it is rejected?
the
Where it is?
application is rejected, my page 40.
40, huh?
Page 40, my lord.
Which one?
Last
Remarks,
box,
applicant
my lord.
provided, hearing so and so, applicant forward additionally, deputy rejected, NOC cannot be issued. As per LM report, TS case is going on. Yes, this,
No, my lord, that is not my case number has not been given, my lord. I have collected, my lord. I am not party in that case, my lord. And that number of my land, my lord, is 1014, my lord. And 1007 land is involved in this case, my lord.
huh?
My lord, patta number 1007 is involved in this
Have you
case.
said so?
Yes, my lord. Kindly see. Page 34, kindly see, my lord.
Have you made any statement here?
Page 34, my lord.
I am asking whether you have made any statement because you are challenging this rejection where it says that in view of the pendency of title suit, it says CO's remark, as per LM report, TS case is going on.
Yes, my lord. But no case number has been given. I have collected.
Forget about that. When you are saying that there's no case number, then have you made any
Yes,
statement?
yes, my lord. I have made a statement.
Where it is?
My lord, paragraph 9, my lord. Paragraph 9, page 10, my lord, of my writ petition.
No, no. You said that this is another patta land?
Yes, my lord, kindly see page 34 now.
No, no, well, not. You have not made any. You are just saying that you have not been made a dependent, right?
Yes, my lord.
And the same has been mutated after the filing of the title suit. Therefore, this cannot be.
No, my lord.
Your matter, your land is not involved. This is simply you are saying.
Last part, my lord. Moreover, the said title suit was filed on so and so, and the name of the present petitioner has been mutated on so and so.
Yes.
Months after
So
filing.
you are relying this mutation only, page 34.
No, page 34, my
You
lord.
have not clearly said that this is not the land
lord,
which you are seeking.
My lord, even the 3 Municip Code also has said, my lord, in that document, my lord, that no case is pending.
Huh?
No case is pending, my lord, in the name of the
You file affidavit. That matter is
very
pending.
urgent matter, my lord.
Huh?
My husband is suffering from heart, my lord. He is to take in.
See, you are not clear about your case.
No, my lord, I am clear because here, my lord, I am differentiating, my lord, the dag number, patta number. My patta of my land is.
You just take the instruction whether this land is, although there may be connected matter pending, whether the particular land which of the petitioner is involved in this title suit. Huh? Or Mr. So-and-so land council, Mullah.
My lord. AFNU.
Mullah.
AFNU.
I know. AFNU Mullah. Mullah. Land council for the petitioner. MS B. Burman. M. Burman. London Council, State Council is granted 3 weeks time to file affidavit. It is made clear that the states shall clearly delineate the land of the petitioner and the land pending in the title suit in their affidavit.
My lord, may I pray for a date, my lord? Very urgent matter, my lord.
What is this?
My lord, very urgent matter, my lord.
2025 matter.
No, my lord. My husband, my lord, he is having heart pressure, my lord. Pacemaker has been fixed, my lord, but he is to be taken out.
It's
my
okay,
lord.
we'll see. We'll see.
I will sell my property, my lord.
Huh?
I will sell my own property, my lord. And in this, my lord, crucial time, if I cannot sell my property for treatment, my lord.
Mullaji,
Kindly appreciate this.
Yeah.
My lord.
Yes.
My lord, a date, my lord, kindly.
Then
Date.
after 4 weeks. Because it's of no point fixing earlier early that.
I got listed, my lord, by mentioning. This matter was mentioned, matter, my lord.
Therefore,
Honorable Court considered my prayer, my lord.
okay. Give after 4 months.
I mean, 4 weeks.
Maybe after 3 weeks, my lord, date, my lord. 23rd? Little ago, I pray, my lord.
Can you file within a week?
Lordship, holidays in between, so I need at least 2 weeks, my lord.
For us, though, there is no holiday.
This 26 January and all these things, my lord, this is there, my lord. So within 1 week, it will be little difficult, my lord. If
But-
2 weeks I may be given, I'll.
Country of
definitely.
festival. Still, we're in third or fifth powerful economy in the world.
Lordship,
I'll just share one thing. In 1992, the Prime Minister of Russia came to India. After visiting 7 days here, he went back and he said, in the whole world, if there is a God, it's only in India. And it was asked, he said, because despite all these, festivals and all this laziness, all this thing, still the country is progressing and leaps and bounds. So today where the country is in the, one of the, top economy in the world. So we have the God here, despite all this country of festivals. Don't take it seriously. I'm on a lighter note.
because I cannot change the system also.
Duly obliged, my lord.
Obliged.
Some more time, my lord.
Yes. Mr.
P. Dev,
Piketeka,
P. Dev,
B. Dev,
Time,
Learned Counsel for the petitioner. On the prayer of Mr. And thus, London State Council further 3 weeks' time is granted to
Lordship,
file
kindly
affidavit.
date may be fixed, your lordship.
16 February,
Obliged.
equality.
Lordship.
Yes. Yeah. Non appears for the prisoner on call. Mr. Endes is granted further 2 weeks' time, 3 weeks' time to file affidavit. 67, whatever 65? 65, yes.
There is an IA, my lord, I have filed for impleading of the Assam Board of Revenue, my lord. Because pursuant to the order, my lord, of 1910-25 by the Honorable Court, my lord, liberty has been granted, my lord, to implead, my lord, the Assam Board of Revenue, my lord.
Heard Mr. G. Alam Learned Counsel for the petitioner.
Para 3, my lord.
Which one?
Para 3, my lord, I
Oh.
paid for impleading Assam Board of Revenue, my lord.
Where you have not made.
Yes, my lord, para 3, my lord, in the IA, my lord. So I filed an IA for impleading, my lord.
Yeah, Alam Learned Counsel for the petitioner. Applicant. And Mr. As
Respondent
Dr.
1 and
for
2.
respondent number 1 and 2. By filing this application, the applicant has sought for implement of the Assam Board of Revenue, Guwahati, as party respondent. Number 3 in the connected WPC 7396 of 2025. Next para. Why you have not made party?
Initially, my lord, inadvertently, my lord, this Assam Board of Revenue, I have challenged the order of the court.
The applicant
has challenged the, what is that?
Orders of the Assam
Orders
Board of Review.
passed by the orders that was 1611, 2023, 2811, 8/2025, and 18/09/2025, passed in case number 64, RA capital, within bracket L bracket close oblique 2023 by the Assam Board of Revenue in the connected WPC 7396 of 2025. This stuff. While the petitioner, the applicant submits that due to inadvertent mistake, the Board of Revenue, the Assam Board of Revenue has not been made as added as party respondents. Although the board, said board is a necessary party. List of, therefore, praise for implement, praise for implement of the said board as party respondent. List of, having considered that the Assam Board of Revenue would be a necessary party, and and also considering that the prayer for implement of the Assam Board of having been not opposed by learned counsel for the rest of the I deem it appropriate to allow this application accordingly. The Assam Board of Revenue represented by Chairman Panbaja, Guwahati District Kamrup within M bracket close, Assam, is allowed to be implemented as party respondent number 3 in the connected writ petition so and so, in IA so and so, in view of the order passing so and so, you file so and so. You will appear. You will appear on behalf of Revenue. No. Then, on filing of amended cost title, the registry to incorporate the newly implemented respondent number 3, thereafter issue notice on steps being taken by the constable of the petition.
There is an interim order.
Interim order process shall continue. Yes.
Can it be fixed on 23rd?
Of why?
It is a short matter, it can be disposed of.
Yeah. Based on notice has to come back.
Yes.
Let the notice come back. We'll see. First, the respondent notice has to be served. All right. List the matter after 4 weeks. 67, call 67.
Item 67.
We'll finish it all. Yes.
On behalf of respondent number 5.
Yes.
Counsel for the respondent number 5.
Yes, sure. Who is for petitioner? You are for?
Appearing on behalf of the counsel for the respondent number 5, Lordship.
5. Rajesh Kumar Jalan. Non appears for the petitioner on call. Mr. DJ Kapil. Are you a DJ or RJ? Would like to be DJ, not RJ.
This is good.
Then why you I say DJ Kapil?
But that's the advice, Lordship.
I have come across. I mean, 15 years back, one DJ Kapil in that. So I can never forget you, your name. Mr. DJ Kapil appears for. You're appearing first time.
No, they already appeared.
I
appeared on behalf of Mr. Jia.
Appearing on Mr. Learned Council appeared on behalf of
G. Rahul.
G. Rahul on behalf of the respondent number 5. Then 6, 7, 8, 9 are the performer respondents. So yes, yes. And
Notice was issued as per the last order, Lordship.
okay, await service reports on this in respect of respondent number 6 to 9, but they are performer respondents. You have not filed affidavit.
No, Lordship, once they will find.
Okay.
Because they are also.
Then I'll say on the Mr. I'll go ahead and learn it. Counsel for respondent number
124.
for respondent 1, 2, 3 and 4. Press for is granted for the 3 weeks time to file affidavits. List after 3 weeks. Sorry.
Please allow for it. But there is a report by,
Yes.
there is a report order by Lojiva Court 812 for presumption of service as regard respondent number 5.
Or Mr. RS, what is it?
R. Dubey.
Huh?
R. Dubey.
R. Dubey. Learn counsel for the petition. In view of the order of Lajima Court 18/12/2025, service in respect of respondent 4 and 5. The services in respect of respondent number 4 and 5 are complete. MS R. Burman, Learned Counsel is granted. And then state counsel is granted 2 weeks time to file it. Okay, who submits that the affidavit has been. She has filed the affidavit on behalf of the state, state response. List the matter after 3 weeks.
Deeply obliged.
And list the item, list the matter for admission after 3 weeks.
So there is an interim order which.
Interim order process will continue.
Deeply obliged.
2017, what is the matter?
But it's regard eviction, my lord. 4 and 5 are the main respondents, my lord, against we have alleged, my lord.
Who there?
My lord, there is a one school authority, my lord. So they are not appearing.
This land is government land or what?
My lord, they claim to be, my lord, but we say that we have been
They'll
positive.
decide. What is your stand? We'll decide today.
For settlement of land, my lord.
And
our application is
they-
also pending.
The land
We
is,
have clear stand mentioned in our affidavit, my lord, that they are not landless people. They have plenty of lands and accordingly,
the land is whom they are staying, on which they are staying, claiming,
yes, my lord,
is
that
a government land or private land?
they were permitted by the private respondents to stay there, my lord.
Where is your role then? What is your role then?
Then
Who are you to say all these things?
land is government land, my lord,
Yeah, that's why I'm asking. If it's a government land,
government land. And they have also,
I'll address your lordships on this issue, my lord.
maybe decide, huh?
Well, I'll address your lordship on that issue.
You address now.
But not now, my lord.
Why?
But I have some difficulty at that. My lord,
After
take a-
2 weeks,
Yes,
we'll decide
my lord,
whether to 3 or 4.
my lord.
4 or 5, doesn't matter. It's a government land, right? Prepare for,
Yes, yes, but I'll
but-
address your lordship.
make your preparation for vacating the land.
My lord.
That's why I'm giving 2 weeks. Why? What is the matter? What is to be done today?
last order, my lord, paper publication was directed. Probably they have made paper publication and affidavit has already been filed.
My lord, by order dated 9/9/2025, we are permitted to make paper publication of notice and file an affidavit in compliance thereto.
Yes.
We have made paper publication and
On when? Heard MS so-and-so, learn counsel for the petitioner. You are for petitioner. You are for the petitioner. Madam, you are for petitioner. You are appearing for number? Paper publication is for respondent number 6.
Petition.
You are staying, why you are staying? Come this side. Heard MS so-and-so, learn counsel for the petitioner. And MS M. Burman, learn state counsel. An affidavit. An affidavit has been filed. Showing the proof of paper publication for for notice for service of for affecting service of notice upon respondent number 6. List of perusal of the same indicates that the same was published on 26/11/2025 in the Assamese Vernacular newspaper. Christoph. In view of above, the service in respect of respondent number 6 is deemed to be completed. November, right?
26 November.
This is the matter for admission after 4 weeks.
Wait, please, my lord.
Yes.
On 1st of December, the time was granted to the petitioner for making an additional statements, reply to the affidavit in opposition. So, my lord, another 1 week or 2 week may be given, my lord.
On the prayer of so-and-so, then counsel for the further 1 week. Further a week's time is granted to file affidavit in reply. Mr. Chettiar.
M.
Chettiar, and State Council is present.
My lord, my name may be recorded.
Obviously, your name, please tell your name.
In the causes is not shown. Somehow I would have missed it, but they helped me. D. Sinha.
Your name, please.
D. Sinha, my lord.
D. Sinha.
Yes.
MS D. Sinha.
MSD.
Singha or Sinha?
Sinha.
Sinha. Okay.
Deeply obliged, my lord.
Complied.
CLT has been, that part has been complied, payment will be begun as per CLT, my lord. It is CL number 65 and 66, my lord. And it will, as per terms, CLT has been maintained, that has been consolidated list has been prepared, and affidavit will be filed, my lord. And the CL it will be this, my lord.
So, heard Mr. So-and-so, learned counsel for the petitioner, and Mr. S. Bora, learned counsel for the, learned Alice Contemner.
1 and 3.
1 and 3. It is submitted at the, but the order of this court.
Yes,
Dated.
Order at 19/8/21. Order at 19/8/21.
19/8/2021 passed in WPC 4570 of 2020 has been complied with accordingly. The contempt petition stands closed.
May I please, your lordship? Lordship, as per order dated 23/5/2022, notice was issued, Lordship, and duly notice has served, Lordship. So matter may be fixed for admission hearing in the month of March, Lordship.
Notice is completed. Notice in respect of respondent number?
All the respondent, Lordship. Respondent number 1 to 6, Lords.
Heard, Mister?
You, Ghosh, Lordship, on behalf of
Yugoslavian
60.
Council for the petitioner. Notices in respect of respondents are complete. List for admission after 4 weeks.
Lordship, can it be listed on in the month of March, Lordship?
Why?
Lordship, some urgency is there as per senior.
When you are saying that there is a urgent, you are seeking after a month, more than a month.
Yes, Lordship.
As spread for list the matter in the month of March,
Obliged.
2026.
May I please with your lordship?
Yes.
In this case, your lordship, very piquant fact arises, lordship. That a very piquant fact in this case, lordship, as because lordship, the earlier lordship, there is a honorable court order issuance of disability certificate. Now, lordship, the petitioner is a 50% disability, but as per the office notes submitted by the joint director, lordship, before the Registry of Guwahati High Court clarifying that, lordship, that the notice has been issued to the petitioner, lordship, to attend the medical board, lordship. But actually, lordship, the petitioner did not receive any notice. But subsequent stage, your lordship, there is a order, there is a letter dated 19 August 25, lordship, wherein petitioner was asked to attend before the medical board constituted by the joint director held Dorong, lordship. Accordingly, petitioner was attended before the medical board, but the authority neither informed the petitioner that the previous occasion.
Is it
the
listed for
medical
today? Is it
board has
listed
been
for that only today?
Your lordship?
Is it listed for consideration of your submission today?
Yes, your lordship. So lordship.
Who is respondent number 3?
But lordship, if your lordship has respondent number 3 is the respondent number 3 is the joint director. Mohondo, lordship.
Yeah, who is appear for state?
But I am willing to appear before the medical board, but if may can be fixed, time and venue may can be fixed, I will attend.
We don't know anything today. Nobody is there.
Yes, but lordship, the one another, the MSCT case has
No,
already
this
been
is
disposed
listed
of.
for this thing, service.
No, lordship, the office note dated, lordship, even the letter submitted by the joint health director, there is a available on record, your lordship, the joint director as well as the superintendent itself received the notice, lordship. There is a, can you be perused the letter dated?
You kindly see the order, not office note, there is 7/1/2026.
Lordship, I have seen it, but your lordship, the.
See, who is respondent number 3?
Respondent number 3 is the joint director.
Problem is that you have made him as a by name. You have added as a by name.
Yes, lordship, the Binod Kolita.
Why you have made his by name?
By name Binod Kolita. Subsequent stage, lordship, IA has been filed for changing the cost title. Subsequently, but IA number 2095, order dated 16/7/2025, lordship. The honorable court has permitted me to arrange the name of the new joint director. Accordingly, I have arranged and again submitted.
Wait, by which order?
By honorable court order dated in IA number 16/7/25.
16.7?
25 in IA number 209525.
Corrected address of respondent 1 3 have been mentioned in the petition. After going through same petition allowed permitting the applicant will take steps to self-blame.
So I have collected and sending letter to them, but in the meantime, joint director as well as the superintendent Guwahati Medical College Lordship submitted letter before.
Madam, who is appearing? Joint director and all this director. So you are not saying anything then?
For the disability certificate, Lordship, the last 1.5 years has pending this
Get a
case,
instruction.
Lordship, and unimpacted remain. So the petitioner is the 50% disability, he cannot move before the MSCT tribunal, only non-availability of disability certificate. So kindly their appearance may be required in this case, Your Lord. And time and venue may be fixed. I
Not
will
Mr.
attend it.
So-and-so, learned counsel for the petitioner. This is contempt case. This is contempt case.
Contempt case, yes, Your Lord.
So,
Contempt case.
so
Get our instruction, Lordship. For the first time we're appearing, we will get our instruction.
on the prayer of Miss MS so-and-so, learned counsel appearing on behalf of Alice Contempt, 2 weeks time is granted to take instruction.
Your Lordship.
Have you heard what he has submitted? Have you understood what he has submitted? Tell us what you have understood.
Non-students of disability.
You tell her
Yeah, disability.
what is to be done
Yes.
and take instruction.
But Your Lordship, the some document has
Thank you.
submitted with the record, so I
Thank
may be
you.
permitted to collect it, Lordship. By
File
Xerox
an
copy,
application. File an application.
Same copy has not served upon me, but the record reflect that same has been served to me.
Mintuji, I have not understood any head and tail. So you discuss with her and we'll fix them. We have fixed the matter after 2 weeks. She will
That
come
may
back with
kindly
the
be
instruction.
fixed, Lord.
Huh?
That may kindly be fixed, Lordship. That is urgent as because Your Lordship, non-issuance of disability.
Mintuji, I have not understood anything. I cannot fix the
Your
date. Sorry.
Lordship has understood everything, Your Lordship.
Yes.
Therefore, Lordship,
Next.
fix the date, Your Lordship. Otherwise, Lordship, the disability, non-issuance of disability.
We'll see after 2 weeks. You just
Your
discuss
Lordship
with
can
her.
fix the date. That is my limited prayer, Lordship.
Yes.
That may kindly be fixed.
May I please, Lordship. Lordship, as per order dated 29/8/2025, we have taken step, Lordship.
Huh.
But as per official date, notice was unserved, Lordship.
You find out.
We have taken steps.
Press take steps.
On 5/9, I have taken a step.
Fresh steps.
Yes, Lordship.
Office note, heard Mr.
Aryan.
Office note indicates, office note 20/12/25 indicates that unserved notice has unserved notice has been returned from, received back from, sorry, has been received back from respondent number 2. To the postal note that the addressee has left. Mr. In the above, then counsel for the petitioner to submit to file the correct address and take press steps. So find out the correct find out his address and take press steps. This after 4 weeks. Yes.
My lord, the lordship would recollect this is a matter where termination of the contract.
Yes, you are supposed to take
Yes.
instruction. Yes, Datta sir.
I have received an instruction from the year, from the authority.
Saying what?
my lord, a copy has been handed over to me also.
Hmm.
It says, because the account section is writing to the administrative side.
Hmm.
He says, once I receive a instruction, then I will release him. But
Hmm.
there is nothing to wait, my lord, because once the termination is held to be bad, that means it is on account of the employer's fault. So therefore, they are supposed to return as the bank guarantee, that's all. Last paragraph is important. Once release order received from executive side towards release of the BG, this office claim towards encashment will be withdrawn. Normally what happens, my lord, because the contract was terminated, so the logical consequence is, my lord, the BG is also forfeited. It is in that context it was done. Now there is a subsequent event whereby this honorable court has pronounced upon illegality of the termination.
Therefore, nothing left to perform, so performance has to come back.
Yes, what do you say?
My lord,
Regarding,
my lord, if your lordship will kindly permit me, I think the writ petition is before your lordships.
Hmm.
Just one paragraph, my lord, page 282 of the writ petition.
this petition is not there.
Hey, writ petition from 9 is it?
Only IA. No, this is IA. Only IA. This IA only.
My lord, I'm just reading that clause, my lord.
Ah.
Upon termination on account of authority default under clause 21.2, return of performance security and retention money forthwith. So we are trying to invoke this clause only. And page 10 of the IA, my lord, we have quoted that. Page 10.
Page 10.
This is the meaning of authority. Yes.
Notwithstanding anything herein above, authorities shall be entitled to determine and terminate the agreement at any time, should in the authority's opinion, cessation of work becomes necessary owing to paucity of fund or any other cause whatsoever, in which case it will be treated as authority's default and termination contract payment shall be made as per clause 21.6. And 21.6 is the one which I have read, Miller.
They have to.
So, but they have told you that give the Miller against your lordship's order, they have not preferred any appeal. So that order has attained finality. That means the termination was bad on account of authority's fault. The only consequence is, my lord, they are supposed to return the bank guarantee, which they are not saying no, but they are taking lot of time, my lord.
No, that's why instead of we direct them.
Yes.
Last order is very clear.
Yes.
That the respondent author is already in the process of, he said, considering prayers of applicant in this application. Then we have passed the order, said complete the interpretation with regard to prayer. Yes.
My prayer is that some procedure is there that the executive side to release the four
That
accounts.
cannot be.
Four accounts, my lord.
My lord, as a last
You
month,
are
my
not
lord,
opposing the,
let the matter be listed on Wednesday. My learned friend will place the order of release, my lord.
Because this instruction says that they will release. Accounts is saying that we will release.
Because accounts also says, once I get instruction from the executive, I'll release by the instruction of 25(1), 5th(1). So let them do that, my learned friend, on Wednesday, my lord.
Are you agreeable? Agreeable.
Because
We should not, we don't want to,
the issue is.
sir, let us be very fair. We don't want you to be on the hot water. We'll pass an order and then
Under the authority of the NFLUA, my lord. They will do, they will do.
yeah, then we'll give you a chance. Otherwise, on next day, we'll not adjourn, we'll not give you
Yes,
further
yes,
time, we'll
yes.
pass the order. Direct you to release forthwith. We'll not go into whether this case is, application is mentally or not.
Yes, yes.
Is enough is enough. All right?
My lord.
But consider that you should not also be in the hot water. All right?
Request them, my lord, okay, because there may be some procedure.
No, we're not saying
No,
that.
this application was filed in September.
Yes.
Today we are in January. And we are paying interest to the bank.
Had Mr. Ken Chodri, London Senior Counsel, assisted by Mr.
E. Gautam, my lord.
D. Gautam, London Counsel for the applicant. This court, considering the submissions of London, Mr. A.K. Datta, London CJC, that the respondents are in the process of considering the prayers of the applicant in the instant application, comma, granted time till today, i.e. 21/01/2026, to complete the process. List of, however, today, Mr. Datta, London CJC again requests for a week's time to complete the process. Complete the process, think about it.
For consideration of the prayer of the petitioners. my
Well,
lord.
last time we said I cannot review my own order unless there is an application to complete the entire process. List the matter as agreed to by
On
London Council
29th,
for
my
the
lord.
parties. Is this matter on
29th.
29?
Yes.
Kindly complete it unnecessary.
Yes.
One minute, sir.
I'm extremely sorry, my lord. Item 67. The orders, my lord, I'm for the petitioner, my lord.
So what I said, what order was passed?
My lord, I was not there, my lord. I was expecting this will be called after the daily list, my lord.
Then we'll record his name, Mr. B. Kosing,
My
huh?
lord.
Then what is this?
My lord, here the, my lord, IOCL though was directed to complete its instruction in the first day itself, my lord. Because there is a division bench order.
Which ICL?
He is appearing for IOCL.
What order was passed? No, what order was passed?
My lord, that is, your lordship will find 25/07/2025.
No. In the earlier, today what order we have passed?
They sought time to file their affidavit, 3 weeks' time has been granted.
It's okay then.
My lord will kindly just put one thing, my lord. There is a division bench order where your lordship was with the Honorable Chief Justice, my lord, has passed an order only for 6 months in 2023. And my lord, this is a clear violation of the division bench order also. The first order, my lord, 25/07.
DJ Kapil will also appear.
Yes.
It's
Here, my
okay.
lord, the IOCL need to
To obtain instruction, there you said, you add that, heard Mr.
Well,
I mean, you just, okay. Heard Mr. B. Kaushik, London Council for the petition, 67, huh? Mr. So-and-so, huh? London Council appearing on Mr. M.K. Chaudhary, London Senior Counsel for IOCL, and Mr. G. Rahul, DJ Kapil, London Council appearing Mr. G. Rahul for respondent number 5. 3 weeks' time is granted to obtain instruction and to file affidavit. That's all. List after 3 weeks.